Good afternoon. Today is February 18th. Welcome to the bill hearings for the Ways and Means Committee. I do not see Delegate Chi. Oh, there I do see you. Okay. Delegate Chi, House Bill 168.
Good afternoon, Madam Chair and Madam Vice Chair and the members of the Ways and Means Committee. It's great to be back here to this committee again. I am Delegate Lily Chi, for the record, here to present Bill HB 168. HB 168 seeks to bring parity to Maryland manufacturing by exempting business personal property taxes for manufacturing equipment and inventory if the businesses are located within municipalities. You might have remembered from last year, it's pretty much the same bill. This committee should have also received an amendment that better defines SMEs, small, medium-sized businesses, to be under 50 employees. Currently, the state of Maryland collects no business personal property tax at the state level, and almost all counties in Maryland also exempt such taxes. But at the municipal level, many, approximately 2 out of 3, still collect a business personal property tax. Since the vast majority of Maryland manufacturing businesses are located outside of many municipalities, we have essentially created a class of manufacturing businesses to be subject to extra burden of business personal property taxes. Furthermore, the rates of this tax vary widely across each municipality. One may charge 2%, while another just a half mile down the street would be like a 0.8%. Both are within the same county. That creates a lot of confusion and uncertainty for a business to make decisions about expansion and relocation. Manufacturing, as we all know, is a strategic industry in Maryland, accounting for 62% of our state's exports, basically 2 out of 3, and $27 billion of Maryland's GDP. We are, in fact, on the cusp of a manufacturing renaissance in our state, just like the rest of America. In fact, Governor Westmore made a strong commitment to growing Maryland manufacturing by investing $11 million to that industry to make more in Maryland. However, manufacturing is also a very high risk and a capital intensive industry because of the need for equipment and inventory. To be clear, businesses should pay taxes, but to levy taxes on the very equipment and inventory they must use for production is tying up their hands and impeding their ability to pay down their debt, hire employees, and generate more tax revenues for our local communities. HB 168 seeks to level the playing field for these small businesses to enable their growth and create a sense of certainty wherever they are in our state. Since this bill is sponsor only, I want to point out that it has broad support from the business community across the state and different industries. You can see written testimonies from Baltimore, Montgomery, chambers of commerce, and from the tech industry to the manufacturing industries, of course. At a time like this, with great fiscal uncertainty, it's easy to argue that we cannot afford any tax cuts to locales that need revenues. But a time like this is exactly when we need to be serious about supporting, not impeding, business growth to build a stronger tax base so we don't put undue burdens on existing businesses and the residents. Thank you for your consideration, and I'm prepared to answer questions.
Thank you. Are there any questions? Okay, seeing none, thank you very much. That concludes the hearing on House Bill 168.
Thank you.
Delegate Otto.
Thank you.
Come on up. House Bill 791.
Thank you, Madam Chair, and I appreciate this opportunity to come before you. I am Delegate Charles Otto, Delegation Chair for Somerset County and representative for District 38A. Before us is a bill that would designate an emergency services portion of the property tax that the county commissioners levy for emergency services operations. We're in a tragic situation at the time. Now we have a fire company that's going to cease ambulance services in the county that covers about half the geographical area of the county at the end of the year, and we're putting this forward. The county is going to have to take a greater role in that responsibility, and they want to designate a portion of the property tax to those services. And it's not a new taxing authority, but it will go through the regular budget process, and that's why it's a June 1st effective date. And I ask your favorable report for this bill.
Okay, thank you. Are there any questions? Delegate Hartman.
Thank you, Madam Chair. Did the delegation vote on it? The county?
Yes,
Somerset
we
County?
met, and I had struggled with myself, and I had a unanimous consensus. And if you need a letter, I hope we have already provided that. And the county commissioners have a support letter as well as at their request. And actually, the emergency services director and one county commissioner came to Annapolis today to testify, but we're not able to. So I ask for your favorable report.
We do have a letter. We did receive that. Thank you.
Any additional things you may need, please ask me. And
Okay, thank you.
it's a local bill.
Thank you, Delegate Otto. That concludes the hearing on House Bill 791, House Bill 949. Delegate Fisher, come on up.
Well, good afternoon, esteemed members of the Ways and Means Committee. Before you is House Bill 949, titled Calvert County Payment in lieu of Taxes Agreements Qualified Data Center. The bill effectively authorizes Calvert County to enter into a negotiated payment in lieu of taxes pilot agreement with the owner of a qualified data center that is located or locates in the county. The bill is supported by all of the county commissioners and the delegation. The only member of the delegation that hasn't voted is Delegate Long. He's not voting on any legislation in the delegation, but Senator Mike Jackson, Senator Bailey, so all the Calvert County senators, Delegate Todd Morgan, and myself. So it's supported.
Okay, are there any questions? Okay, seeing none, thank you very much. That concludes the hearing on House Bill 949. Delegate Fisher, House Bill 998.
Thank you, Madam Chairwoman and members of the committee. Before you is House Bill 998, titled Calvert County Property Tax Credit Tobacco Barns. The bill authorizes Calvert County to grant by law a property tax credit against the county property tax imposed on real property that was formerly used as a tobacco barn if the real property is located on land that's subject to a tobacco buyout agreement or is located on land that qualifies for an agricultural use assessment and is used in connection with activity recognized by the State Department of Assessments and Taxation as approved agricultural activity. The county commissioners, of course, are just looking for the authorization to be able to implement this as they see best. The goal is to save these tobacco barns. With that, I'd be happy to answer any questions, as always.
Okay, are there any questions? Delegate Young?
Thank you, Madam Chair. Quick question, Delegate. Just tell me what a tobacco barn is. Thank you.
Say again, I'm sorry.
What is a tobacco barn?
What is a tobacco barn? Well, interestingly enough, I was born and raised in Baltimore, so I'm not from Calvert County, from tobacco country, but I have been there most of my adult life. And the tobacco barns that were built in Calvert County over the course of basically when the Calverts came and the Ark of the Dove came to southern Maryland, they built tobacco barns and started growing tobacco, and they stored tobacco upside down and dried it in the barns. And so one of the questions that we've had in Calvert County, which is a fair question, some people just build barns, but they're not tobacco barns. They had to be traditionally used as a tobacco barn over the years, and then they also had to be part of the agricultural tobacco buyout. And that's kind of important. And what happens, and as you can imagine, is we have a lot of people who move to the county. There will be an historic tobacco barn on the property, and they're not looking at it as having any value, so they'll knock it down. So we're just trying to figure out a way of keeping them restored because they are kind of cool looking.
Understood. Thank you so much. Thank you, Madam
course.
Chair.
Okay, any other questions? Okay, seeing none, thank you very much.
Thank you, Madam Chairwoman.
That concludes the hearing on House Bill 998. Now House Bill 7. Okay, good afternoon, committee. My name is Delegate Vanessa Atterbury, and I am here to ask for your favorable report on House Bill 790. House Bill 790 builds upon the foundation laid by last year's unanimous passage and enactment of House Bill 54, transfer to heir and legatee payment plans. This bill aims to ensure that homeowners across Maryland are properly informed about their eligibility for the state's property tax payment plan. House Bill 790 will provide the necessary outreach and education to taxpayers, helping prevent financial hardship and empowering homeowners to take control of their property tax payments. House Bill 54 established Maryland's property tax payment plan. This initiative was designed to help property owners avoid falling behind on taxes and accumulating costly interest and late fees. However, while House Bill 54 established the program, House Bill 790 is a critical communication component that will ensure its successful implementation. The core provisions of House Bill 790 requires the state tax sale ombudsman to maintain a website with key information about the property tax payment plan. The website would prominently display the following language, quote, if you would like to pay your property taxes in monthly installments, you may be eligible to enroll in an installment payment plan, end quote. Additionally, the site will offer a complete description of the program and clear detailed instructions on how to enroll. The bill also requires local tax collectors to include a separate insert with each property tax bill they send out to residents. The insert would carry the same statement about potential eligibility for the payment plan and would provide concise details about the program. Furthermore, the insert would include step-by-step instructions on how homeowners can enroll in the installment payment plan or any available local installment payment plan. The bill also ensures that local tax collectors, when applicable, are responsible for designing the insert if local installment payment programs are available. Local tax collectors who already maintain a website will be required to feature the same information. By providing this additional layer of communication, House Bill 790 ensures that every homeowner has the necessary tools to prevent falling into tax delinquency, and this is a reasonable step towards safeguarding homeowners from tax-related financial struggles. And with that, I ask for your favorable report.
Thank you, Madam Chair. Any questions? Delia Buckle.
And Madam Chair, you mentioned that we created this program fairly recently, which to me makes a tremendous amount of sense to let people pay this off in installments. Sometimes people don't have $2,000 or $3,000 or $4,000 just laying around free that month, but they could build it into their monthly or yearly budgets. Is it already up, to your understanding, is it already up and operational so that there's a, I'm not very techie. And every time we come in here, somebody who works in the tech end says, we don't have a program that can accept it this way, or we don't have a setup, basically. Is it already up and running in most places or through SDAT, to your knowledge?
I don't believe so, but if Mr. Ward could respond to that.
Oh, sure. I wasn't trying to, yeah. Stand the man.
Council button. There you go.
Yeah, so the program isn't up yet, but it's expected to be up in the next year or so. But SDAT has asked for an amendment to delay the effective date just so that this comes into effect after the program is operational.
So that's kind of what I was getting at. So we would do this in conjunction if and when it gets fully rolled out technically. And that, to me, I mean, the $500,000 local impact, I mean, we all hate to pass costs. We know we're passing costs along with localities. That seemed a little high to me. I mean, you're not prescribing that they do something. I read what the bill said, you could just add that in 2 or 3 sentences on the existing piece of paper or
Right.
electronically, whatever.
Right.
This isn't some brand-new thing that all the counties are going to have to spend a bunch of money on.
Right.
Okay, thank you.
Thank you, Madam Chair.
you.
Seeing no other questions, that ends the bill hearing on House Bill 790. As Madam Chair returns to her seat, we will call up House Bill 983, Delegate Maricopa North on election law.
Okay. Thank you, Madam Chair. Chair Iberry, Vice Chair Wilkins, and esteemed members of my committee, Ways and Means Committee. It's my pleasure to come before you on House Bill 983, Election Law, Local Board of Elections, Language-Related Assistance. Currently, Maryland relies on provisions of the Federal Voting Rights Act to mandate translation of election materials in our jurisdiction. However, as we enter an era of increasing uncertainty on the continuation of these federal voting rights bills, it's essential that Maryland creates its own provisions to continue to expand our ability to provide multilingual election materials. As Maryland continues to grow as one of the nation's most diverse states, with the 2020 census reporting 136 languages and dialects spoken within our borders, and 1 in 5 Marylanders speaking a language other than home, this bill is a necessary step for our election system to better reflect and accommodate the rich diversity at the ballot box. So the bill is pretty dense, so I'm going to try to give you some highlights of it. So the key provisions of the bill, it's going to lower the language access threshold. Under the bill, the Maryland language access threshold will be triggered when at least 2% or no more than 100 voting age individuals or 4,000 citizens of voting age in a county speak a language other than English. So currently we rely on the federal requirement, which is at 5%, 10,000, but for this Maryland provision, we're lowering it. It also enhances the language services, which would be the responsibility of the local boards. So local boards would translate registration and voting forms and notices, election-related materials, sample ballots, and there will be signs posted at voting centers and precinct locations for early voting and election day, and they'll be displayed in language meeting the county threshold, informing voters of available languages, language assistance, and interpreter services. There's also provision in there for giving oral instructions for those who have languages that are oral or unwritten, like sign language. The local boards will provide language assistance, but making sure that the materials translated are of equal quality and available at the same time as the English versions. And these translations are not going to be relied solely on automated translation like artificial intelligence or machine learning. Election judges will make reasonable efforts to be fluent in the required languages, and that's the responsibility of the local board. The State Board of Election has to make the determination that, quote, a significant and substantial need for language-related assistance by a local board during an election exists. So they're the ones to make determinations, and the local board essentially does the work after the determination is made by the State Board. The State Board of Election will also have a publication of designated languages and local boards be published starting January 1st, 2026, and every 2 years thereafter. They're also going to have a review process for the language designations that allows voters, groups of voters and organizations to request that a language be designated for assistance, and there'll be an opportunity for public comment. And that's on page 4 of the bill. In terms of the Attorney General's role in this, they're going to be able to issue subpoenas, conduct fact-finding hearings to enforce provisions of the bill if there are any particular complaints on the process. For those that are a person or organization that's aggrieved by any lack of enforcement of this bill, they'll be able to file an action to enforce the provisions. Now, the bill is silent as to who pays for, because really we're pretty open as to how that's done. I know MACO filed a motion, filed a position favorable with amendments discussing the issue of the localities being burdened with the pay. We're pretty open as to how that is done. Every jurisdiction is different. I know Rockville, they've taken on the responsibility of paying for their election-related materials to be in different languages, but that really depends upon the relationship between the state board elections and the particular locality. And I know I saw Jared Damaris in the audience, if he's still, okay, right, front and center, and he can answer any question in terms of the current status of the relationship between the state board elections and local counties that want to have multilingual election materials. So this bill, this is introduced last session, is sponsored only. This year has been so far endorsed by Latino Caucus, and this bill will definitely, once passed, increase the number of counties that offer Spanish materials and different for different voting election-related materials. And for other counties, it will increase. I know Howard County, I think it will increase particular Asian language, I think it was Korean, and then Montgomery County, possibly Amharic. It just depends upon again, the threshold being met as designed in the bill. So that's essentially the nuts and bolts of the bill. I ask for your favorable report on House Bill 983.
Okay, thank you. Questions, Delegate Buckle?
Chair, thank you, Delegate Mercu North, and we're both attorneys. I'm kind of looking at a weird attorney provision of
Sure.
this. As we know, most of these things, if there's ever really a dispute, it winds up, somebody has to go to court.
Yeah.
I'm taking a look, it just seems a little bit more than usual in page 5, section 15.5-106 of your bill. The people who have standing as conferred by the bill to file to effectuate its goals. So it includes, I'm looking at that subparagraph 3 and 4, an organization whose mission would be frustrated by a violation of this section, or an organization that would expend resources to fulfill its mission as a result of violation of this section. I just have some concerns about those, and I think that, you know, the language, I'm sure you didn't specifically say, hey, that's my exact language. It was drafted by somebody, it came through DLS, however it came through.
Right.
It seems pretty broad.
Okay.
And it would seem to me, would it be fair if we chose to pass the bill, if we could amend it, wouldn't we pick pretty much everybody up that we want if we just had subsection 1 and 2, an aggrieved person, somebody who speaks some other language as their primary language and can't otherwise participate in voting would probably qualify, or number 2, an organization whose membership includes or is likely to include aggrieved persons. So if there's a group, a recognized organization out there with legal standing that includes enough of those people that fit in category 1, would we really need 3 and 4? I'm just asking the question. I mean,
No, I
I've
appreciate
read a lot of statutes with standing, and that language is pretty unique from what I've seen.
Okay, I appreciate that. That's definitely a friendly suggestion. I could definitely take it to the stakeholders and see what we can do about beefing up that language.
Okay,
But thank
I
you
just
for
want to
that.
highlight that. Thank you.
Delegate Young.
Thank you, Madam Chair. So this is for the Secretary first. Pardon me for not knowing the extent of all of the laws. Is it illegal to take your cell phone into a voting booth and use it?
Talking to
Director Demaritis?
Administrator.
You wanna, yeah, if you
can come on
want to
up.
come forward.
Oh, his light's on, okay.
Sorry. I want to be respectful. Wrong title.
Jared Demaritis, State Administrator of Elections, for the record. So use of cell phones is a kind of a difficult subject for everything. Basically, it is used, if the cell phone is used to help assist the voter, or the voter uses it for assistance, like if they have their specimen ballots, then yes, they're supposed to use it. But at the same time, cell phones are not just cell phones because they have cameras and video and everything else. So, you know, we kind of try to not allow a complete access with them. I mean, if you're using it for your own personal stuff there, then yes, but like you cannot like video everything else out there. And we kind of make a more of a saying that it's prohibited to kind of use cell phones in those facilities there because it's difficult to monitor a person maybe taking a photo or trying to do something outside of that.
Let me ask you this from a practical sense, considering the intent of the bill, which I think is a great bill. And obviously, y'all know where I'm going with this. With a cell phone, you can translate. would it be problematic for the board if part of the materials that was provided was materials to show people an Android version, an Apple version of how to do a translation on your phone? You know what I mean?
So I think this is where we're exploring new technologies, and I've worked with the delegate a lot on this. Right now, we had a pilot program in Prince George's County where we had a language assistance program where there was tablets available at early voting centers that allowed individuals who English is not their first language to seek a translator for any language out there. We then did the same pilot not only just on the early voting centers, but polling places, and they had the election judges then had iPhones in which then they can get translators to communicate with individuals. We have already started to put up I would say the voter registration application and the mail-in ballot applications in multiple languages on our websites. So there are we are looking at using technology to help facilitate access for, individuals that English is not their first language.
But you all wouldn't be at least open to, so I just want to be clear about a one-pager of instructions for an Android or Apple device. Would that be something? Say it again. But couldn't they take that? Could they take that in? Could y'all hand that out? Would that be something y'all would be?
I guess we can talk more offline about this, but but the thing is, I guess I'm always committed to using new technology to help facilitate voters in making sure that they understand the ballot and how they're voting.
Yeah, and Madam Chair, just to conclude, I appreciate everything, but obviously I'm thinking about at a certain point when glasses are overlaying things right in front of you, which I think is in the next 3 years, if it takes that long. But, we'll cross that bridge when we get there. Thank you, Madam Chair.
Delegate Miller.
Thank you, Madam Chair, and thank you for bringing the bill. And so my question is along the same lines is, so where you were talking about the presence of bilingual election judges where available, so would you want, if they were available, would you want them there all the times the polling places are open? How do you envision that working? Because I'm assuming you don't want people to request in advance or anything.
Well, yeah, I would say, this is part of this, how I ended my written testimony, that in terms of what the state board can do to help the localities. And, as Mr. Mayor has mentioned, there's a lot of technology out there and it's constantly evolving. And so I hear you on the point of how long the election judges will be there. My gut reaction is as long as any other election judge would be there, they shouldn't be treated any differently than election judges who are not bilingual. The key is to make every effort to actually get those bilingual election judges. And so it definitely is truly a working relationship between the localities and the State Board of Elections. Not every county is going to have the same relationship in terms of how to treat those election judges.
So,
Right, and I get.
I guess once you're assigned a location, you're assigned a location.
Yeah.
We're not going to yes. So
move them around.
Right. So we would probably seek and right now we do ask for bilingual election judges, and yes, once they get assigned, they're assigned to that location. It's not like then they're moved, and I think that's why as the state board, we're looking at new technologies to help facilitate voting again.
Right, and so the tablets that you're talking about, were they solely used for accessing interpreters?
Yes.
Or with the earbud and then you would show them what you're looking at, or you would talk back? How did that work?
So it was actually a program that I'm very happy about, and we actually put it in for the EAC for an award. It's basically, so it's a tablet, it becomes a video call. So the translator pops up on the tablet. The election judge then speaks directly to the translator then speaks to the voter, and the voter then comes back and forth. It is, there's no headsets. They would gone off to the side for that. But, they went through it and spoke, they're fluent in multiple languages right then and there for them, and it goes back and forth like seamlessly through it, but it's a video call.
Yeah, what I like about, because I had a chance to view the pilot program for Georges County, is that it's live person. It's very much a conversation that's happening in terms of what questions they have about particular parts of the ballot. And so it was very fluid, very fluid.
And then for people that, where we wouldn't have a ballot in their language, or could they use, instead of bringing your phone into it, into the voting booth or taking pictures or whatever rules are under that, could you use the tablet for that same purpose with Google Translate or something along those lines?
They could ask questions about what does this language mean, or something like that.
Right, but could you set it up where they wouldn't have to be speaking to an interpreter? Because there's a cost. Anytime you have an interpreter, and interpreters are expensive, so there's a cost for the locals there and the availability of that person. So would you be able to use that tablet instead of using your phone to do a Google Translate type situation? Would you be able to use the tablet for it?
So I think the tablet is still used with judges to help facilitate that. It's not necessarily to go through it, because at one point, the other portion about this is to make sure that we want to make sure that the translator is not saying things that is not correct or influencing the process in any sort of way. So that's why you have the election judge there, and the translator is just translating the directions from the election judge to the voter, and the voter back to the election judge, as if this was a normal transaction, like for anybody that would speak English.
Okay. All right, thank you.
Delegate Plakovich-Carr.
Thank you, Madam Chair, and thank you, Delegate Mercury North, for this bill. So just two really quick questions. One, I remember last year, I think the bill included municipalities. Is that, they're not in the bill this year, is that right?
Yes, I think we weren't, it was a cost issue, and we just didn't want to have this appearance that we're trying to overburden these studies, because, Rockville's budget's different from Mount Rainier or whatever, so we wanted to just keep it at the counties this time.
Okay, great, thank you. And then second, when I was trying to read through this quickly, I just wanted to confirm, so the translation requirements don't include the ballots themselves, right? Like you're talking about anything else, the sample ballots, the other kinds of assistance, but not the ballots themselves.
Correct,
okay, great.
correct.
Thank you.
Mm-hmm.
Delegate Long.
Thank you, Madam Chair. Question I have is, this is only for certain jurisdictions. Montgomery County and other jurisdictions allow citizens that are not United States citizens to vote. Am I correct? Is that what
No, in fact, and I thank you for that, because I wanted to highlight that there should have been an amendment sent to everyone that we were talking about citizen voting age population, not just voting age population, so specifically those that are eligible to vote.
Okay, one of my concerns, and I'd like to ask you, what's your thoughts? If someone doesn't speak fluent English, we want to make absolutely sure, how can we actually make absolutely sure somebody's voting is not supposed to be voting?
Well, that's why we put in the amendment to clarify. They were talking about people that are registered to vote, citizens able to vote in the population. That will, if enough people are existing in a particular county, will trigger the mandate for the localities to do the materials. So we wouldn't have a need to worry about those that are ineligible to vote to participate, because we're specifically talking about citizens. That's why we put in the amendment to clarify that.
Okay, I guess last thing, if I could, excuse me, with same-day registration and voting, are there any concerns about that as far as, possibly leading someone voting that shouldn't be voting?
Well, this bill doesn't specifically address same-day voting in concept, but we do address the fact that we're asking for local boards, if they meet that threshold, to provide the translated registration materials.
Okay, thank you.
Mm-hmm.
Okay, are there any other questions? Okay, seeing none, thank you.
Thank you so much.
That concludes the hearing on House Bill 983. Is Delegate Kaiser here? Okay, we are going to, Delegate Bouchat? Nope, there, I'm looking right past you, apparently. House Bill 890. And
Thank you, Chairwoman, or Madam Chair. Boucher, for the record,
Boucher.
like the water boy.
There are two witnesses. Would you like them to come up later?
Yes, please.
Okay, go right ahead, whenever you're ready.
Thank you very much. I'm here to present House Bill 890. It is a bill to allow party changing during the primary. This legislation is aimed at addressing inequities in Maryland's primary election process. This proposed legislation seeks to grant registered voters the ability to change their party affiliation during the primary elections, a right currently available only to unregistered voters. HB 890 does not establish an open primary system, but instead allows voters to switch party affiliations during the primary period. This change would amplify moderate voices in the political process, reducing polarization and the fostering of broader representation. I was motivated to bring this bill forward after reading former Lieutenant Governor Boyd Rutherford's Sun editorial in December of 2024, in which he stated, opening primaries to unaffiliated voters is one way to increase citizens' participation in our elections. It may cause candidates to appeal to a wider audience than their narrow party-based activists. And I happen to agree. This might be as a surprise to some of my colleagues, but I ran 6 times for my party's nomination before I finally won. The language in the bill is very simple. On page 2, lines 20 to 23, it states, during a primary election, a voter may appear in person at an early voting center or precinct polling place and change the voter's political party affiliation and vote the ballot for the voter's new political party affiliation. I think this is very, very important considering what we have been told historically, starting all the way back with George Washington's farewell address in 1796. Quote, the alternate domination of one fraction over another, sharpened by spirit of revenge, natural to party dissension, which in different ages and countries has perpetuated the most horrid enormities, is itself a frightful disposition. But this leads at length to a more formal and permanent disposition. I mean, it's tough to read sometimes Old English, but I think the point he is making is that party fractions drive us in opposite directions, when in reality, we as legislators need to come closer to the center. And I think that's really what the populace is asking of us. At present, 21% of the population's registered voters are unaffiliated. That's 1 in 5 citizens are excluded from participating in the primary election process. And we as politicians understand that the elections are primarily decided in the primary election process. And it would behoove us all to attract more people into the primary election process. And with that, I will accept questions.
Okay, are there any? Okay, thank you very much.
Thank you, that was easy enough. Y'all have a lovely day.
That concludes the hearing on House Bill 890. Madam Vice Chair, House Bill 945. Yes. David Naaman, probably mispronounced that.
Thank you, Madam Chair, and greetings to all of the distinguished members of the Ways and Means Committee. For the record, I am Delegate Janelle Wilkins, and I'm pleased to present House Bill 945. This bill suggests a change in the date for the 2026 statewide gubernatorial primary election and beyond. Right now, the law says that the statewide gubernatorial primary election shall take place on the last Tuesday in June. This bill changes the date to the 4th Tuesday in June. The reason for this change is that from time to time, there are 5 Tuesdays in June. And by having it on the last Tuesday, particularly in those years, it ends up falling into Father's Day and Juneteenth. And we know that those are important holidays to our residents. It can impact voter turnout. It can also impact access to the buildings that we normally utilize for early voting and election day, and also the recruitment of our election judges as they're often maybe people who are traveling or otherwise unable to participate due to the holidays. So the effect of this bill is that it would change the election day next year to be June 22nd, 2026. In most years, in many years, it won't have any effect. But again, for those years where we do have 5 Tuesdays in the month of June, it would move it to make sure that it's the 4th Tuesday. With that, I ask for a favorable report on House Bill 945.
Thank you, Chair Atterbury and Vice Chair Wilkins, members of the Ways and Means Committee. My name is David Naiman. I'm the president of the Montgomery County Board of Elections. I'd like to thank my friend Delegate Wilkins for introducing this important legislation. Our county board proposed and strongly and unanimously on a bipartisan basis supports this legislation. It's a very modest but important change in the electoral calendar. As Delegate Wilkins explained, it's a one-week change. It's not every election, but it does happen with some regularity. Basically, the goal here is to move the election away from the holidays when you can. When there are 4 Tuesdays in June, you really can't, but when there are 5, you can. And also to move it closer to the end of the school year. And the reason, there are numerous reasons for that. It's a benefit to voters, election administrators, and election workers across the state. It probably will result in higher in-person voter turnout, a greater ability for voters to pick which method of voting they want to use, a higher number of election judges, and shorter lines for in-person voting. In addition to not coinciding with those holidays, by being closer to the end of the school year, you'd be avoiding the long weekend that Juneteenth and Father's Day would create. You'd be avoiding summer vacations. You would also be avoiding, by being closer to the end of school, recreation department summer camps that use the same facilities that we try to use for early voting. If early voting is before school ends, there are no summer camps to conflict with us. And then school officials often do renovations over the summer to their school buildings. In some past elections, we've lost as many as 10% of our election day polling places in that fashion. We don't want our voters to be confused as to where their polling places are, or to think that we're trying to confuse them, which of course we are not. By having election day closer to the end of school, those renovations can be delayed, and those buildings would be available as the normal polling places where voters vote. So thank you very much, and I urge a favorable report on this bill.
Okay, thank you. Are there any questions? Okay, thank you very much. Mr. Lang, you were signed up to testify in favor.
Oh, you're up.
Yes. Madam Chair and fellow members of the committee, my name is Alan Lang from Harwood, Maryland. This will be quick. I asked for a favorable report for Bill 945. Looking at the bill, I saw the presidential primary election is held on the 4th Tuesday in April. The city primary election is held on the 4th Tuesday in April. It just seemed like it would make everything consistent by having the gubernatorial primary be the 4th Tuesday of the month. Thank you.
Thank you. Any questions for Mr. Lang? Okay, seeing none, thank you very much. That concludes the hearing on House Bill 945. Folks, I'm going to circle back to 890. Delegate Boucher. I'm going to circle back to Delegate Boucher's bill. Because Mr. Lang come up, you were signed up to testify on that. House Bill 890, and I apologize, change of party political affiliation. Would you like to testify on that one? Come on up. And then do we have Linda Cohn here? So you can bring her up. She signed up on that one as well. I apologize.
That's good. Madam Chair, fellow members of the committee, I'm Alan Lang from Harwood, Maryland. And
would you like to?
Okay. I support the bill. I believe if one can register to vote at an early voting center for a primary election or at the precinct polling place on the day of the primary, I don't see why voters already registered should be prevented from changing their party affiliation at either place. I did have a protocol issue, but I think the state board person has left. I see in the policy notes that according to them that we would have, the person would have to vote by darn, by provisional ballot, and I was wondering if someone would ask him why that would be so, when the people, if I understand it, if you register on the day of the election or if you register at the early voting, you vote with a regular ballot. So I was just wondering if someone could ask why that is so, because that would by going provisional, that drives up all the costs for this bill.
I think Mr. Ward, our counsel, has an answer to your question, just for the public to know.
The state board would know the details, but as I understand it, the computer system, the electronic poll books can't accommodate just issuing a regular ballot in that circumstance. So it's a technical issue, as I understand it.
All right, but regardless, I still would like you to put in a favorable report. Thank you.
Thank you very much. Okay, Ms. Cohen, I apologize. I skipped you all on the last bill, but please go ahead for 2 minutes.
Great, thank you. Chair Atterbury, Vice Chair Wilkins, and members of the committee. I'm Linda Cohn. I'm president of the League of Women Voters of Maryland, and I'm here to testify in support of HB 890 that would allow voters to change their party affiliation at early voting and on election day and vote for the newly selected party. And the operative term there is "and vote." Although the bill does not specify unaffiliated voters are the most affected by the rules for primary elections. You've run for offices. I hope you're aware that there are almost 1 million voters out there in Maryland who are left out of the process. That's how many unaffiliated voters there are. As a league, we are nonpartisan. We do not concern ourselves, worry about how somebody votes. Not our issue, not my issue, absolutely. But people do have to vote. They do need to vote. That's how the democracy works. And we know that there's no question that we need more people to participate in the voting, and particularly around the primaries. In the 2024 primary, turnout among Republicans was 29%. Turnout among Democrats was 31%. In my book, that's still too low. But among the unaffiliated voters, it was 8% turnout, single digits. Those are voters who are registered. They've gone through the process. They're eligible to vote, but they're not allowed to. When we disenfranchise 1 in 5 voters in this state, the results cannot be representative because we've left out too many people. This bill moves in the direction of allowing more voters to participate, and for that reason, we urge a favorable report. Thank you.
Thank you. Are there any questions? Okay, thank you very much. And now that concludes the hearing on Delegate Boucher's House Bill 890. House Bill 906, Delegate Plakovich-Carr. And would you like Morgan Drayton to come up with you? Yep.
Good afternoon, colleagues. For the record, I'm Delegate Julie Plakovich-Carr, here to present House Bill 906. This bill seeks to crack down on entities who are engaging in fraud that is masquerading as political activity. Scam political action committees, aka scam PACs, are groups that claim to collect donations for a political candidate or cause only to pocket the money for themselves. And this bill will provide the State Board of Elections with enhanced tools to combat scam PACs and to safeguard donors. And I want to start by sharing a real-life example from here in Maryland. In 2016, a resident of Catonsville created a PAC that advertised the chance to win a dinner with Donald Trump. The PAC spent a small fortune on Facebook ads and ultimately raised more than $1 million from 20,000 donors. But no one ever won that dinner, nor did then-candidate Trump receive any campaign contributions from this PAC. Instead, the PAC founder used the money he raised to pay off personal debts, to buy a luxury car, to go on vacations, and for other personal uses. Such examples of fraud are unfortunately growing in Maryland and across the nation, as has been documented by both the FBI and the Federal Election Commission. But it's been unfortunately very hard to crack down on this type of fraud. For instance, that Catonsville resident who claimed to raise money for Trump was prosecuted not for fraud, but for failing to file an income tax return. And he got a year of probation, had to pay taxes owed, but still got to keep some of the money that he stole from donors. The Federal Election Commission has called for Congress to act to pass new laws to crack down on scam PACs, but that hasn't happened yet. But there are actions that states can take to protect donors. So this bill would ensure that would-be scam PACs are subject to appropriate scrutiny by the State Board of Elections, and that the board can impose civil penalties for wrongdoing. Under the bill, scam PACs and entities that make independent expenditures would be required, or excuse me, super PACs and entities that make independent expenditures would be required to include a disclosure when they are claiming to represent a candidate, stating that they are making the solicitation without the express consent or authorization of the candidate. So this bill will make it easier for donors to vet the legitimacy of political causes and give appropriate tools for the state board to crack down on fraud. And I'll just finish up by saying I have submitted a sponsor amendment to the committee to clarify some of the provisions in the bill based on feedback that we got from the state board. Thank you.
Good afternoon, Chair Atterbury, Vice Chair Wilkins, and members of the committee. My name is Morgan Drayton with Common Cause Maryland, here in support of HB 906, which, as we just heard, increases transparency around scam PACs and empowers the state administrator to fully investigate any future violations. I want to thank Delegate Plakovich-Carr for bringing this very important legislation. It's important because we know that these scam PACs erode the trust in the political process and discourages the public from engaging with that process. And that just makes it all the more harder for legitimate political action committees and campaigns to raise those funds that they need to win elections. Without knowing the signs, it's very easy for well-intentioned and unsuspecting donors to fall suspect to scam PACs, mistaking them for legitimate charities or legitimate political groups. And at a time when trust in public institutions is very low, it's very important that we take these steps to protect Marylanders and provide the tools for SBE to investigate and prevent any future wrongdoings. So with that, we would request a favorable report. Thank you.
Questions, Delegate Hornberger.
Thank you, Madam Chair. We've heard a number of bills this year and have in the past. I definitely appreciate what you're trying to do about deep fakes and sort of all of these things that nefarious groups, entities, or individuals would do during an election. My question for you is when someone takes it upon himself to do this, they don't say, hey, I'm a scam PAC and I'm out here scamming people. So how do we, if we were to pass all of these bills, how do we know what to go after for these actors? Because at the end of the day, they're all committing campaign fraud. So why aren't we sort of casting a wide net? Because what seems to be happening in every election cycle is that someone comes forward with a new angle. And criminals are very opportunistic, and they tend to seek out things that are on the edge of being legal so that they can get away with these crimes, as you just alluded to with your anecdote. So why aren't we looking at more holistically at campaign fraud as opposed to just a single instance?
That's a good question. I probably don't have a full answer to that today, because you're right, we have heard a number of other bills on this subject. And I guess my expertise in election law is not enough to know is there a more holistic solution? So, I mean, I think if you and I want to talk with SP Administrator Demarinis about, like, is there something else we could be pursuing? I'd be very interested in what that answer is. You know, in the particular case of this bill, I'll just say I think you're exactly right that people who have criminal intent with what they're doing, you know, are going to find ways to move forward. But I think this is a reasonable step that we can take at this point to start to figure that out. Because right now the state board is having trouble even figuring out that these things are out there.
Sure. Okay, thank you.
Okay, any further questions? Okay, seeing none, thank you very much. That concludes the hearing on House Bill 906. Delegate Acevedo, House Bill 874. Oh, wait, I'm sorry. Delegate, Mr. Lang, I'm sorry, come on up. On House Bill 906, you are unfavorable. I apologize.
Madam Chair, fellow members of the committee, I'm Alan Lang from Harwood, Maryland. Sorry I brought my cloak of invisibility today. But I generally would be in favor of the bill, but I have a question. It seems to make sense that if no PAC should be able to use the likeness of the candidate in ads without their permission. And I can see the need for a PAC to make a disclosure if it did not receive permission. And it seems to make sense that if they're doing something that would not be eligible for a donation, that you should tell the people that. The question I have for the sponsors of the bill is that the bill doesn't apply to all PACs. Maybe I don't understand the law properly, but in particular, PACs with corporations and PACs by unions are excluded from this bill. I wondered why that was so, and if they're going to be exempted, then I would think, unless this applies to all PACs, that you should enter an unfavorable report.
Okay, any questions? Thank you. Okay, that concludes the hearing on House Bill 906. Delegate Acevero, House Bill 874. And let's see if Jacqueline Coolidge is here virtually to testify in favor. Concludes the hearing on House Bill 906. Delegate Acevero, House Bill. Okay, Ms. Coolidge, if you have a live stream on, can you stop the live stream? Thank you. And Delegate Acevero, whenever you're ready.
Thank you, Madam Chair, members of the committee. For the record, Delegate Gabriel Acevero here to present House Bill 874. The bill seeks to repeal the special use assessment for property tax purposes for certain country clubs and golf courses. Now, it should come as no surprise to any member of this committee, to the General Assembly, and really to the constituents that we serve, that we are in a significant budget deficit of close to $3 billion. And our current tax structure provides significant financial advantages to private country clubs and golf courses by assessing their property at a lower rate than other types of real estate. These clubs, which often maintain vast green spaces, benefit from public infrastructure and resources while remaining inaccessible to the general public. Membership fees for these clubs are typically substantial, to the tunes of over $100,000 or more, and creating an exclusive environment that does not serve the broader community. House Bill 874 aims to eliminate this inequity by repealing the special use assessment to ensure that these properties are assessed based on their market value like other types of real property. This change would lead to a more just and equitable tax system where all property owners contribute their fair share to public services and infrastructure. Moreover, HB 874 supports the responsible and fair allocation of resources and recognizes that as our communities grow, the demand for public services such as schools, emergency services, and infrastructure also increases. By properly assessing country clubs and golf courses, the state can generate billions in additional revenue over time that can be invested back into these essential services, ultimately benefiting all of our communities across our state. By passing HB 874, it is a step towards not just fiscal responsibility, but tax fairness. It acknowledges that while private country clubs have every right to operate as they wish, they should not receive tax benefits that come at the expense of us, the broader public, and other taxpayers. We are in a very serious fiscal situation in our state. We're reminded of that not just by policy analysts, by our colleagues on the other side, but also by our constituents. And so at a time when we need to be looking for revenue and looking at ways to generate revenue, this is an opportunity for us to get to that equitable tax system, generate revenue into our state coffers, but also ensure that this assessment, this setup that was done a few decades ago that gives private country clubs and golf courses this privileged status in our tax system, that ends. If we are serious about reducing the structural deficit that our state faces, we have to stop subsidizing elite private country clubs that the broader public does not have access to and would need to pay thousands of dollars in order to even enjoy the open green spaces that these same private country clubs and golf courses often profess that they are trying to preserve. This bill rights that wrong. It helps us get the revenue that we need. And again, at a time when we have a close to $3 billion deficit, we should not be justifying continuing to give a special subsidy to private country clubs and golf courses that do not need it. And so with that, I ask for a favorable report on House Bill 874. And thank you, Madam Chair and members of the committee, for your indulgence.
Okay, Ms. Coolidge for 2 minutes, please.
Thank you very much. Madam Chairwoman, members of the committee, I'm Jacqueline Coolidge, and I'm speaking on behalf of the League of Women Voters of Maryland. We would like to show our support for House Bill 874. As you may be aware, we have been engaged with a number of the fiscal bills this year. We're acutely aware of the financial crisis, the budget crisis facing both the state and local jurisdictions, which we can only expect is going to become more dire in the months ahead. So we do believe that the exemption that has been enjoyed by the country clubs and golf courses in our state, it is just totally unconscionable for them to continue to receive such a privilege when the fiscal problems of this state and our counties and localities are becoming so onerous. These are not places that are enjoyed by the vast majority of residents of the state of Maryland. I cannot go to a country club with my child and go on the grounds and enjoy the lovely green spaces. I'm not allowed. This is something that benefits a very tiny minority of the population, the most elite and the best, most well-off of our residents. So we very much agree with House Bill 874, and we are urging a favorable report. It would be unconscionable to see this languish because of a lack of attention in this dire circumstance. Thank you.
Okay, questions? We will start with Delegate Buckle.
Madam Chair, and Delegate Acevero and the nice lady who just responded, I appreciate you keep talking about we're in such dire straits, but I look at this bill and I mean, we could get rid of this exemption tomorrow. It's not going to make a penny's drop in $1 million bucket for our state finances. The fiscal note reflects that if we did this tomorrow, the positive effect for state finances would be $521,000. We have a $3 billion budget. That's not even a rounding error in a $3 billion budget deficit to have a 520. And local property taxes may increase by approximately 5.6 million across all 24 counties. So I would suggest that the county that you live in has probably some of the most expensive country clubs in this state. You know, you want to join Burning Tree, you got to pay some money. But if you want to join, say, at Rocky Gap, where I live, I think it's $500. They're 19-year-olds. They're college kids who like golf who are able to scrape together $500 to the privilege to play there. Do you really think, I mean, I just don't think with a straight face this bill would make any difference whatsoever for our finances. I mean, Montgomery County has a multi-billion-dollar budget. Even if you got half of these monies, if you got $2.8 million in additional local tax revenues, it would be a rounding error in your local budget. Is it a desire to really gain revenues, or is it just some sort of like, I don't know, maybe you don't like golf. I like golf a lot less. I'm a lot worse at it than what I used to be. I like it a lot less than what I did, but it just doesn't seem to be a bill that actually would generate real revenues.
Delegate, appreciate the question. I like watching golf. I also like a fair and equitable tax code. And I think when we're talking about this issue, whether we're talking about $500,000, 500 and something thousand annually, that's money that would otherwise go to something else, whether it's youth programs, whether it's resources for our seniors or more investments in our own community. I recall there was a debate on the floor where some of our Republican colleagues refused to vote for a bill because the fiscal note was $500,000, and we're in a very tight budget situation. So the argument that somehow $500,000 doesn't make a difference, I think it does. I think we could find use for that. But this is about the long-term impact of this special assessment and what it has done for our communities and the disinvestment that it has caused. Because of this being in place for decades, we've lost out on millions, not just 500,000. Jurisdictions have lost out on millions of dollars that we could be investing elsewhere. And as you rightly pointed out, I represent a jurisdiction that has a lot of private country clubs that enjoys this special tax assessment. So the fact that a Montgomery County delegate is here introducing this so that we can help to reduce our budget deficit, which is our goal, all of our goals for being here, I would hope that you'd appreciate that.
Yeah, in my 11 years in the committee, this is the 4th or 5th time I've seen the bill. I think all of the sponsors have been from Montgomery County, so I'm not really sure what that is. Would you be interested in maybe just doing as a Montgomery County delegation bill? Do you think your delegation would support that, and then the Montgomery County golf courses wouldn't get the exemption, and you would get those resources locally? Because it really wouldn't add up to very much statewide. And the other question I had for you is, do you object to conservation easements? Because those properties preserved as green spaces, they don't get taxed at highest and best use value either. And so technically we lose a lot more money. When you see the fiscal notes come through this committee over the years, we lose a lot more money by allowing people to say, I own 100 acres of land. I'm not going to build on it. I'm not going to increase sprawl. I'm not going to increase, urbanization. I don't have to pay taxes on it as if it were developed land. Isn't that kind of the same thing here? Because this only applies to the actual green space of the golf courses, the clubhouses, the improvements, the restaurants, the houses alongside of it. They all get assessed at the normal value. They don't get any break. It's just however many acres you have on the fairway, so to speak.
Yeah, so Delegate, you asked 2 questions in that, and I'll answer it, just really, really quickly. The first is, why isn't this a local bill or something that's specific to Montgomery County? It is a bill that I've introduced specific to Montgomery County, and as some of the country clubs in my jurisdiction, and I think it's a fair argument, rightly pointed out, is that this would essentially single out country clubs in Montgomery County, whereas country clubs in the rest of the state continue to enjoy this special tax assessment or this subsidy. So it wouldn't be fair to ask country clubs in my county to stop being subsidized by the taxpayer while all other country clubs in the rest of the state enjoy that subsidy. So as a matter of equity, we're making this bill a statewide as opposed to a jurisdiction-specific bill. Now, on your second question about green space, green space is something that should be publicly accessible. It should be enjoyed by every single member of the public, especially if we're talking about preserving open and green spaces. And if the only way the public are able to enjoy open and green space or to spend time, in green spaces is to pay hundreds or in some cases thousands of dollars to be members of a private country club, is that really in the public interest when we talk about open and green space? And I would argue that it doesn't. And so, we could find better uses for open and green space other than subsidizing private country clubs that, again, is not accessible to everyone.
I appreciate your earnestness and good faith in the question. I mean, I would just say conservation easements are generally not open to the public. If I own 30 acres of green space and I devote it for a conservation easement or a farming easement, that doesn't mean that everybody can now just walk onto it. It's still my private property. It just gets assessed differently because I basically agreed to place some kind of a cap upon its future development and use that changes its characterization. But I appreciate the bill. We've seen it before, and thank you for your presentation.
Thanks for the questions.
Delegate Young.
Thank you, Madam Chair. So I know I like golf. I just started a couple years ago. It's great. Trying to make my green fees go up, bro. But that being said, frankly, I don't think $1 of my money should go to subsidizing rich people playing golf at a private course. That being said, I don't think it's a bad idea that you took some of this money and helped support the public courses, which I can assure you $500,000 will go a very long way, especially in the 5 courses, including the 2 in my district, where the paths are bumping when you're riding. There's a lot of work that can be done with just a few thousand, let alone 500 annually. So I would submit to you that an amendment to that effect to maybe direct the money to supporting the public courses would be helpful. But that being said, under the bill, it seems like public courses are already also getting some sort of a special use assessment and thus being taxed as well. Can you talk about the potential impact that this bill would have on the public courses and their tax liability?
Yeah, Delegate, I'm happy to follow up with you on that. The bill really, and I think you raise a good point about, what we could do to I guess, fund or support public golf courses. But the bill essentially is designed to ensure that we end that special use or special assessment, rather, that gives country clubs money that they would otherwise pay that they're not. And it's been mentioned a few times what this would bring in annually, but this is about what we've lost over time. Because we have not been assessing property the way it should for the past decade or so, we have lost out in hundreds of millions of dollars. So we can talk about the net, what we would generate annually, but this is about what we've lost over time and what we'll continue to lose over time if we do not change this special use, this special assessment that a lot of private country clubs and golf courses enjoy. Now, in terms of public golf courses, happy to follow up with you on that, on like whether it's the amendment and where some of these funds can go. But we want to ensure that there is equity and fairness in this.
And to clarify, not just where they can go, but the public courses have to pay a property tax too, so I want to see how this impacts that. Thank you, Madam Chair.
Delegate Griffith.
Thank you, Madam Chair, and thanks for bringing this bill. And I want to follow up on Delegate Jones' questions because that's where my head was at. I was reading the bill, and I don't see any carve-out for public courses, for courses that are, you just walk up, pay to play, courses where high school kids go and play for their high school team competitiveness, things of that nature, because we have public courses closing across the state, lots of golf courses that are designed for the average Joe, $50, greens fees. Like Harford County high school teams have to play on public courses in Pennsylvania because we ran out of courses for them to play in Maryland, right? And that's a problem. So I don't see any carve out in this for those opportunities to allow low-income folks to be able to play on these golf courses, because those tax exemptions allow some of these lower dollar golf courses to exist, which gives more opportunity for access to sports like golf for everyone across the state. Can you address about the lack of carve out for not just, we're not talking about, not every golf course is the big $100,000 golf course. There are some $500 or just you pay greens fees and that's it. There are no memberships on these golf courses. Can you talk about how your bill would impact those public type golf courses?
Yeah, I appreciate the point. I'm certainly open to amendments as it relates to public golf courses and making sure that that's, not only, we're preserving, but folks have access to that. I don't have a sponsor amendment as it relates to this bill in terms of any particular carve out, but certainly open to suggestions on amendment as it relates to public golf courses. This, however, what we wanted to ensure that we were honing in or getting at was, again, the private country clubs and golf courses that enjoy this assessment, that aren't paying what they would otherwise would or should be paying, and ensuring that we're getting the money from that. But certainly open to amendments, Delegate, and good point about the public golf courses.
Thank you very much. Thank you, Madam Chair.
Delegate Hornberger.
Thank you, Madam Chair. I haven't been on the committee for a number of years, heard this bill before. One of the things that wasn't discussed is sort of the aggregate tax look at. So golf courses are one of the only things in Maryland that we also tax as far as admissions and amusement tax. So these can be levied by the county or the municipality, and sometimes both. And they're from 1% to 10% of all the receipts that occur at this place of business. So are you willing to sort of relax the admissions and amusement tax to kind of offset this? Because even though they may be paying a lower property tax, for example, they're paying other taxes that businesses in the same space are not. So, in my district, we've had golf courses that have failed. In other words, they've shuttered, and now they're developed, or now they're sitting vacant, and all of a sudden it went from generating a decent amount of taxes to zero. So, you have to look at maybe a reprieve on some of these other taxes as well that just apply to them.
Yeah, I appreciate that, Delegate, especially around the you said the admissions?
Admissions and amusement tax. So currently, we only tax roller rinks, drive-in movie theaters, golf
Right.
courses, and amusements. As you could probably tell, many of those don't exist anymore. Golf courses are just one of those things that got put in the bill many years ago, but haven't been able to get a reprieve. So it's important to look at the aggregate tax rate and what goes to the local jurisdictions.
Okay, any other questions? Okay, seeing none, thank you very much to both of you. Now, unfavorables, we have Todd Chamberlain and Tiffany Harvey.
Thank you. You want me to go first?
You want me to go?
Whatever you want to do.
Hello. Good morning, Madam Chair and committee members. My name is Todd Chamberlain, and I am the president of Kenwood Golf and Country Club in Bethesda, Maryland. I'm here to ask the committee for an unfavorable report on House Bill 874 because this bill would financially crush golf courses across the state. My interest in this bill is deeply personal. Since 1928, my family has run Kenwood Country Club. My grandfather started it, he ran it, then my dad took over, and then he ran it, and then when my dad passed away, I've run it. And my goal is to pass this on for the fourth generation. We are a small family club, and we are not congressional, we are not Chevy Chase, we're not some of the big hitters. But there's so much in this bill that was already discussed that nobody has taken into consideration, like the taxes that we already do pay. But this is the community that we serve, we've served it for 97 years. We're about to come up on our 100th birthday. And you don't get to that position by treating your vendors poorly, your community poorly, or your staff poorly. And the amount of goodwill that we put out toward the public, we do the First Tee program. We let Georgetown Golf come and play on our facility. We let Landon, we let Whitman. The other day, when it was too cold, the Whitman lacrosse team asked if they could practice in our indoor facility. We had to think about it, and it was just like, oh my gosh, how can we help our community? When some of the local pools go through a redo, we invite them in and say, hey, do you need to use our pool? So we are deeply involved in our community. This bill, oh shoot.
It's okay.
Okay. Okay. This bill would devastate us financially. It would crush us. And my goal is not, and if we do have to sell it, there's just going to be a whole bunch of houses there, and it's not going to go, and the community will suffer drastically for it. I could go on, and I would love to have a conversation with the other fellow that was in here, but I would like for this committee to vote unfavorable for House Bill 874.
Thank you. Ms. Harvey?
Sorry for going over.
Thank you, Madam Chair, Madam Vice Chair, honorable members of this committee. My name is Tiffany Harvey, and my firm has the honor of representing the Maryland Coalition of Golf Courses. I get it. A lot of people think that golf is an elitist sport for the wealthy, and it excludes people. But that is not the game of golf that I know and have come to love. Over the past couple of years, I found myself, like the other delegate, Delegate Young, searching for time to play golf. And learning the game of golf, I have come to know a very diverse community of golfers. Older, younger, different socioeconomic backgrounds, varying cultures, varying races. The only thing that really matters is having a good time and trying to hit your ball well. Heavy emphasis on the trying part. Vice Chair, I know you know. My daughter is 11 years old, and at 7 years old, she joined the Howard County First Tee program, which is really exciting for my family because my dad is a longtime golf enthusiast and a coach. So watching him pass down his love for the game has been really fun. If you get a chance, I urge you to take a look at the written submissions we've sent to this committee. You're going to hear from lots of different golf courses, some public, some private, but you will see a very robust golf community, and the state of Maryland. One of the letters I'd point your attention to comes from the Howard County, Greater Baltimore, and Youth on Course letter of opposition. Those are youth programs that benefit from Maryland's golf community. They've taught tens of thousands of children in the state of Maryland, and they teach them things like sportsmanship, character, integrity. I'd also point your attention to the letter about the Evans Scholars Program. Over the past 8 years, 8 of those scholarships have been awarded to students in Maryland schools. And those scholarships, they're need-based, and they cover tuition and housing, and they're valued at over $125,000. With that, I see my time's about to expire. With that, we will lend to our written submission and ask for an unfavorable committee report on this bill. Thank you.
Okay. Could either one of you just tell us what the First Tee program is? I know you know very well, Ms. Harvey, but either one of you, because you mentioned it too, sir.
So yes, they bring people to our golf course, people of all walks of life, mainly the people that usually cannot play golf regularly. They bring them to our course, and then our pros, our assistant pros, they take them out on the course and they show them how to play. They teach them about the honesty of the game. It is very easy to cheat in golf, and that's one of the main things that I feel is more important than the actual game, is actually teaching people to have integrity as you're out there on the course by yourself or with a group of people. And to me, that is more important than the actual game, is the character that First Tee actually develops. And every time they ask to plumb out on our course, we've never said no to them.
Madam Chair, if I can add to that. So the program invites children from ages 7 to 18 years old. They have varying chapters around the country. I think there's more than 200 chapters around the country, and it's an international program as well. So kids come in, and it grabs kids at kind of 2 different levels. One, they have volunteers that work alongside the golf professionals at the various courses that they have, but then they also instruct. And it's really cool to watch because they use physical fitness that's outdoor space. It's getting kids off of computers, off of devices, and learning to love the game of golf and be outside. They're exposed to other golfers, they're exposed to the fun of it, and then it's a skill that they're being taught that lasts a lifetime, right? So that's a little bit about First Tee. There's a very robust program, as mentioned, in Howard County, and there's tuition opportunities, financial assistance for kids who can't afford to play, and they want to bring the kids onto courses and get them exposed. Thank you, committee. Appreciate it.
Thank you, committee members.
On House Bill 874, Delegate Kaiser, House Bill 953.
Thank you, Madam Chair and members of the committee. I would just add that I'm the best golfer that's ever lived, and I've never gotten on a golf course, so you can't prove me wrong. It looks easy. And so there you go. Anyway, thank you, Madam Chair and members. I'm here on House Bill 953 for tax sales regarding the homeowner protection program. As you know, there have been tax sale bills over many years, and this homeowner protection program was created, I don't remember now, 5 or 6 years ago. And it's to try to help people who are in tax sale and try to make things financially better. As you can see from my written testimony, I have a section on how tax sale disproportionately affects elderly, low-income, and minority homeowners, and a lot of story there, and how a small tax bill can grow over time with penalties and fines and other challenges, and how we all know how administrative and government letters can be confusing to us, and for someone who maybe has less agency and maybe less education would have even greater challenge with that, and that when we're in a hole, sometimes we keep digging, unfortunately. This homeowner protection program was created as an alternative process to help homeowners get more help, get more funding, more support. In this bill would require a few specific things, require tax collectors to publish about the homeowners protection program and have more people know about it. That's a challenge we have throughout government, and that we create great programs and great supports, but we do little to put things in front of people. And if we're going to create programs to help people in financial distress, it would be incumbent upon us to actually make them aware of it. This bill also requires a tax sale ombudsman to try to maximize enrollment, Also have the State Department of Assessment and Taxation prohibiting them from charging interest on the unpaid taxes owed to the department, alters funding sources to their homeowner protection program, and some reporting requirements. The goal is to increase outreach, maximize enrollment, and ensure accountability in the homeowner protection program, and make sure that no Marylander loses their home simply because they didn't have the right information at the right time. So I urge your support for House Bill 953. Thank you all very much.
Any questions for Delegate Kaiser? Okay, thank you very much.
Thank you, Madam Chair.
Kevin Canali, come on up. He is favorable with amendment.
Thank you, Madam Chair and members of the committee. Kevin Canali here on behalf of the Maryland Association of Counties in support of the bill with an amendment. As you know, we've been in several times on this program. We support the program, support a lot of the things in the bill, just not the fiscal part. As you probably are also aware, the governor's fiscal plan proposes to shift 90% of SDAT's costs onto county governments. I think our legislative committee feels particularly aggrieved with that provision, and so we support everything in the bill except the fiscal aspect. Happy to work with the bill sponsor and with the committee to try and find another mechanism, but we're facing the same pressures as the state, and we would ask for a favorable report with that amendment, and I'm happy to answer any questions.
Okay, are there any questions? Okay, thank you very much. That concludes the hearing on House Bill 953. Delegate Johnson, you've been waiting patiently. House Bill 969. And would you like, your folks to come up? Absolutely.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Delegate Andre Johnson for the record, and I'm asking for a favorable report on HB 968. Now, I'm from Economic Matters, so my chairman loves what he calls an economy of words. So this is going to be very short. So I'm going to be very short here. This bill aims to bolster rural broadband expansion and ease the tax burden for broadband providers, leading them to better internet accessibility in rural parts of the state. This bill is a win-win for Maryland residents, business owners, and broadband providers. It encourages investment in high-speed internet, leading to stronger communities, better education, better health care, and more economic opportunities for our farmers and folks in rural areas. So with that, I ask for a favorable report, and I'll turn it over to my panel.
Good afternoon, and thank you, Madam Chair, and all the members of the committee. My name is Deanna Subzak, and I'm the Senior Vice President and General Manager of Think Big Networks. We're an internet service provider providing and deploying services in rural counties and small suburban communities in Maryland. Here in Maryland, we have many areas that are either rural or somehow disadvantaged that don't have access to high-speed internet, which is crucial in this day and age. Maryland realized there was no business model that could support these bills and other inequalities and created the Office of Statewide Broadband. Through these programs, broadband providers partner not only with the state, but the counties and the towns to help close the digital divide and bring our capital commitment down to a model that should be sustainable. As an unregulated utility, we are required to report our total billed cost annually to SDAT through the Public Utility Operating Property Return. The problem with this is the filing doesn't take the subsidy into consideration, and the provider is being assessed at the property value that is much higher than it's warranted. In some counties, Think Big, my company, was originally being assessed a property tax bill that was 50% more than our revenue. We had to then go and file an appeal, and we still ended up paying 50% of our revenue for property tax. We believe that this is an unintended consequence and is not sustainable for us as a provider. There's also not a way to pass this expense through to our customers because in many cases, they're already financially disadvantaged. We tried to work with our county partners that wanted to actually help us with this problem, possibly through a pilot program, but their hands were tied because the current law does not allow for pilot programs for broadband providers. We are requesting that the state allows and votes favorable for this, that would allow the counties to adopt pilot programs with broadband providers as needed so that they can assure that Maryland residents have access to this critical infrastructure. Thank you.
Thank you, Madam Chair. I'm Mike Johansson on behalf of Think Big Networks. Ms. Sobczak is here at my request. Let me address the fiscal note. It says $35 million. It's kind of scary. We have a solution that Ms. Sobczak described, which is a local option pilot program only. So if the local government wants to work with their broadband partner to have a payment in lieu of taxes instead of the assessed value, that is an amendment that we will be offering. We would hope that MACO would support it, completely local option, not mandatory. The assessment at the state level would stay unchanged. I wouldn't bring you something that was $35 million and ask you to vote for it. This would be, honestly, the way the bill was drafted is very similar to how public subsidized housing is today. You don't tax an apartment building that is a subsidized housing unit based on its value. You basically look at the rent controls and other public subsidies that have gone into it. But nonetheless, we think the easiest bill for you all to consider and to pass this year is a local option pilot, and that's what we are requesting.
Okay, questions? Delegate Griffith? Oh, you know what? I'm going to ask Mr. Canale to come up. He's favorable with the amendment, and then we'll do all questions together. Thank you.
Thank you. Yep. Good afternoon, Madam Chair, excuse me, and members of the committee. Kevin Canale here on behalf of the Maryland Association of Counties in support of the bill with amendments. You do have my written testimony. The amendment outlined at the table would put MACO in a support position on this bill. So we'd ask for a favorable report with the amendment from the sponsor.
Thank you, Madam Chair, and thanks for being here. So you're telling me that your company is being taxed, property taxed, for the revenue that the state has provided you to fulfill these projects?
So the way that it's structured right now, there's not a line item to subtract the infrastructure cost. So, they're looking at the total cost that we put into the project, which is gross and not net. So if we were given 90% value, if we were given 90% from the state and counties to subsidize it to bring it down to what we consider a business model, we're being taxed at the higher level. And when the tax bills originally came through, we were actually being taxed more than our entire revenue for those particular counties.
So you're saying that your tax bill is greater than your revenue?
Yes.
Thank you.
And I will say we had to file an appeal. We were able to get it down some, but at the end, the net result was still 50% of our revenue, which is unsustainable, and we're looking for a solution.
Thank you.
Thank you.
Okay, any other questions? Okay, thank you very much.
Thank you, Madam Chair.
That concludes the hearing on House Bill 969. We are going to hop over Delegate Roberts' bill because she is hearing a bill in a different committee right now. Delegate Feldmark, House Bill 816. And you have multiple people here signed up. I don't know who you want to bring up, but.
Thank you, Madam Chair, Madam Vice Chair, committee members. For the record, I'm Delegate Jessica Feldmark, here to present House Bill 816. This bill may sound familiar to you. It is actually sort of a combination of two bills that this committee heard last year, one which I presented and one which Delegate Attar presented. And this is dealing with ballot questions. Recognizing that ballot questions are some of the most important, sometimes some of the most controversial issues that our communities care about. And the ballot questions themselves are some of the most confusing pieces of the ballot for many of our voters. And so what this bill aims to do is really simplify the language in which ballot questions are written, and also make sure that if someone wants to go beyond the simple description, they have easy access to the full text of the bill or constitutional amendment or the item that the ballot question is describing. So it also applies those same principles in terms of the plain language to petitions to get a question on the ballot, and makes sure that the ballot question language is available earlier, before the election, and that there's time for public review and comment on that. So I do have a witness panel to speak to this as well, but would ask for your favorable report, and I'm happy to answer any questions.
Good afternoon to the committee. For the record, again, my name is Morgan Drayton with Common Cause Maryland, here in support of HB 816. Thank you to Delegate Feldmark for bringing this legislation and for that wonderful explanation of what it does. Too often, we see that voters are leaving the voting booth unsure of how they voted on a question or having skipped certain questions just because they couldn't be sure what they were being asked. We think that it's very important that voters are conscious and informed of what decisions they're making at the ballot box. It's also important that no voter feels that they've been left behind because of confusing or unclear ballot language. Our current petition and ballot measure language favors the college-educated, though Maryland is a very highly educated state overall, and the ability to comprehend these complicated, sometimes technical questions in language is becoming more widespread. This doesn't reflect the education level of the average Marylander. I've said this before, I'll say it again. This is not meant to question the intelligence of Maryland voters. We're just acknowledging certain realities about the educational level and makeup of our state and making any necessary accommodations just to ensure that voting is equitable for all. And for those reasons, we would request a favorable report. Thank you.
Thank you, Madam Chair Atterbury, Vice Chair Wilkins, and a special thank you to Delegate Feldmark for once again championing this very important bill. I'm Nikki Tyree, Executive Director for the League of Women Voters of Maryland. You have my written testimony, so I will tell you two very important stories about this bill. When I first started with the League, we were approached several times about if there was a way to create the ballots through pictures, because people were not able to process the words. Unfortunately, we haven't gotten there yet, but this bill would speak to that need. The second is about my mother. So my mom is a very intelligent woman. She's educated. She came to a couple of the League's talks in the fall. And still, when she walked into the ballot box during early voting in October, she voted wrong on question 1. And she came home and she admitted, maybe I think I messed up. When I asked her why, she said, well, I listened to everything that was said, but when I went in and read the question back, I just didn't know what I was voting for. And she was so confident she hadn't taken anything with her. But at the end of it, no matter how much she felt prepared, she walked in and she read the question, and she just couldn't tell what the answers meant. So if she voted one way, what would it do? If she voted the other, what would it do? Delegate Feldmark's bill specifically states that all voters in Maryland would be afforded the opportunity to read if you vote yes or no, this is the outcome. This is critical language that we need. We urge a favorable report, and I'm happy to answer any questions.
Okay, are there any questions? Okay, thank you very much. Thank you. Mr. Lang?
Madam Chair, members of the committee, I'm Alan Lang from Harwood, Maryland. I support the bill. When I was in the federal government, we used or tried to use plain language all the time to try to make our notices to the public more understandable. I think it's still a work in process, but doing this would be a great attempt, and I think if we had had this for the last constitutional amendment on abortion, I know people had problems understanding that on both sides of the issue, and I think it would have helped if this had been in place. So please enter a favorable report for this bill.
Okay, thank you very much. That concludes the hearing on House Bill 816. Delegate Roberts, we will circle back. House Bill 781.
Ready? Okay. Madam Chair Atterbury, Vice Chair Wilkins, and esteemed colleagues of the awesome Maryland House of Delegates, Ways and Means Committee. For the record, I am Delegate Denise Roberts, representing District 25 in Prince George's County, and I'm honored to present and respectfully request a favorable report for House Bill 781, the Accessible and Expedited Voting Act of Maryland for elderly and disabled voters. I would like to note that this bill is also cross-filed with Senate Bill 66, sponsored by Senator Arthur Ellis from Charles County. HB 781 is a critical step toward ensuring that every Marylander, regardless of age or ability, can exercise their fundamental right to vote with dignity, ease, and efficiency. This bill prioritizes the needs of two key groups: voters aged 65 and older and voters with disabilities. While Maryland has made significant progress in making and expanding access to the ballot box, too many of our elderly residents and citizens with disabilities continue to face challenges when casting their votes. Some struggle to stand in long lines. Others navigate polling places that are not adequately equipped to accommodate mobility devices, and many face difficulty simply accessing the ballot box in a timely and respectful manner. These barriers do more than create inconvenience. They erode confidence in our democracy and send an unspoken message that some voices matter less than others. This legislation mandates the State Board of Elections to develop clear guidelines for local election boards to implement streamlined and accessible voting processes. Among the key provisions, HB 781 will establish dedicated expedited voting lines for seniors and individuals with disabilities at polling places and early voting centers, ensuring they are not forced to endure discomfort while waiting to cast their ballots. 2, require clearly marked signage to ensure these voters can easily navigate voting sites without confusion or added stress. 3, provide priority seating in waiting areas, recognizing that standing for long periods is not an option for many of our most vulnerable residents. And 4, enhance election judge training to include best practices for assisting elderly voters and voters with disabilities, fostering a culture of inclusivity, patience, and respect. These measures will go into effect starting with the 2026 primary election and will be carefully monitored by effectiveness. The State Board of Elections will report annually to the General Assembly, detailing the implementation process, challenges encountered, and recommendations for improvement. Madam Chair, members of the committee, HB 781 is about fairness, accessibility, and upholding the integrity of our electoral system by making it truly inclusive. No Marylander should feel that their voice is diminished because of physical limitations or age-related challenges. The right to vote should not be hindered by physical discomfort, confusion, or exclusion. By passing this bill, we reaffirm our commitment to democracy that works for all, where every vote is valued equally and every citizen has the opportunity to fully participate in shaping our future. I would like to thank all those who submitted written testimony in support of this legislation, as well as to those who took valuable time to be here in person in support of HB 781. And I also want to make note that the president of the Prince George's County Board of Elections, former District 25 Senator Beatrice Ticknor, has also submitted written testimony in support of HB 781. And for these reasons, I respectfully request a favorable report on House Bill 781. Thank you for attention to this important issue, and I welcome any questions.
Okay, thank you. Are there any questions for Delegate Roberts? Okay, thank you.
Thank you.
We have some folks here in support of the bill: Alan Lang, Morgan Drayton, and favorable with amendment, Sharon Minneke. If you all could come up.
Good afternoon again. Morgan Drayton with Common Cause Maryland, here in support of HB 781. This bill creates new standards for local board of elections to expedite voting and provide accommodations for the elderly and voters with disabilities at each early vote and polling site. These new standards, along with the pre-existing option to use a placeholder in instances where a voter is unable to stand for long periods of time, will go a long way towards making polling and early voting locations as accessible as possible to as many voters as possible. Improving accessibility is how we make sure that everyone has the opportunity to have their voice heard within the state. This legislation also requires local boards of elections to post clear signage letting voters know that these services are available to them. We would ask the committee to consider requiring translation of all signage into any other languages that are spoken widely within that jurisdiction, just to ensure that no eligible voter is left behind in this process. Overall, Common Cause is in support of this bill, and we would request a favorable report. Thank you.
Ms. Minneke, you can go ahead, please.
Thank you, Madam Chairman and Vice Chairman and members of the committee. I'm Sharon Minneke. I'm the Director of Advocacy and Legislation for the National Federation of the Blind of Maryland. We think this is a very good bill. We'd like to make it a little bit better by adding the amendment that people would have the choice to accept an accommodation such as not having to stand in a long line, or the choice to reject it. Now, you might say, that's kind of interesting. So I just want to report to you that really the only people who know the needs of the individuals is that individual. And that's why we're asking for this amendment. Plus, the Americans with Disabilities Act has been in effect. It'll be celebrating its 35th anniversary this July. And it has language in it that you can accept the accommodation or you can reject it if you're a person with a disability. So I ask you to vote in favor of this bill with that amendment.
Okay, Mr. Lang, did you want to testify?
Madam Chair, fellow committee members, based on this bill, I meet the definition of elderly, but currently I don't meet the definition of being disabled. So far, my age hasn't hampered my ability to stand in line and process my ballot. However, recently, I had my mobility restricted temporarily from a broken foot and a sore back. Fortunately, neither occurred during the last election, but if it had occurred on November 5th, it would have been very beneficial for me if there had been a place to sit until it was my turn to check in, or to sit until a voting station was open, because I couldn't stand for very long. I believe that this bill, 781, may be a better approach to assist the elderly and disabled in voting than the bill that would pilot curbside voting, House Bill 317. House Bill 781's approach would not have the technological issues of moving and securing voting equipment outside. Also, 781 and Senate Bill 66 would create an expedited process to reduce the wait, which is what many who testified for curbside voting said would be an advantage of curbside voting. Unlike curbside voting, this bill would allow the elderly and disabled to vote inside like everybody else. So please issue a favorable report for this bill.
Okay, are there any questions? from the committee? Okay, seeing none, thank you all very much. That concludes the hearing for House Bill 781. Calling House Bill 910, Delegate Wolk. And you have Bernice Louder, Bronza, and then virtually Benjamin Danforth and Edwin Jackson. Let's see if they're here. 1 second. Is Bernice Louder here? She's coming. Oh, she's coming? Okay.
Good afternoon, Chair Atterbury, Vice Chair Wilkins, and esteemed members of the Ways and Means Committee. For the record, I am Delegate Sarah Wallach, here to present House Bill 910, Property Tax Exemption for Blind Individuals Alteration. This bill expands an existing property tax exemption for blind individuals or their surviving spouses from $15,000 a year to $40,000 and will pertain to only 1,431 eligible Marylanders. The changes will be applicable for taxable years beginning June 30th, 2025. This bill is a necessary change to help a small and vulnerable population of Marylanders and is simply a revision to keep up with the changed housing prices over the last 25 years. The blind property tax exemption was implemented in the 1950s and was last increased in 2000. Since that time, the cost of living in Maryland has increased significantly, as have housing prices. According to the Federal Housing Finance Agency, from 2000 to 2023, the housing price index increased between 95% and 192% across our state, with Allegheny as the lowest increase at 95% and Worcester as the highest with 192% increase in housing prices. However, the tax exemption has not kept pace. Add to that, the American Community Survey data that indicates that only 46.2% of people with visual impairments were employed in 2019 with a median annual income of $38,500. And I hope you can see that changing the exemption will make a meaningful positive difference. The Maryland State Department of Assessments and Taxation estimates that there are 116,500 blind people in Maryland, and of those, 1,431 of them are eligible for this tax exemption. Eligibility is determined by the same standards as the federal government uses to determine Social Security benefits and does not include people who are renting or children. In total, the blind population makes up about 1.89% of total population in Maryland, but only 0.02% of the total population of 6 million people is eligible to receive this exemption. Thank you for your consideration, and I respectfully ask for a favorable report on House Bill 910.
Bronza, would you like to go? Sure.
Good afternoon. My name is Bernice Louder, and I'm here to ask you to support House Bill 910. First, I want to thank you for giving blind people a property tax exemption. I have been in my home since 1976, and the exemption has been a big help to me over these many years. I needed the tax exemption when I worked for Johns Hopkins Hospital as a medical transcriber in the pathology department. Even though I had a job, I still needed the support of the blind exemption. I stopped working to raise my 3 children. This change in income made me more dependent on the tax exemption. Unfortunately, I am too old to work now. Last year, I called Baltimore City to see if I had lost my exemption because the taxes were so high. The department explained that I was still getting it. Please vote in favor of House Bill 910 so that I and other seniors, other blind seniors can stay in our homes. Thank you very much.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. It's great to be back in Ways and Means. We're immensely grateful for Delegate Wallach's willingness to step in as a champion, just as we were and are grateful to Senator now Attar's leadership and willingness to champion this bill originally prior to her appointment to the Senate. My name is Ronza Othman, and I serve as president of the National Federation of the Blind of Maryland, which is the state's oldest and largest advocacy organization of and for blind, low vision, and deafblind individuals. Many of our members, as you heard, are on fixed incomes. Some have developed blindness later on in life, causing them to leave their work and occupations and as a result, have a decrease in their incomes. Some, like me, are reluctant to buy homes at all because for legally blind individuals, the unemployment rate is well over 73%. And so the likelihood of my finding another job if I lose my current one is quite low. This terrifies me, and I'm afraid that I won't be able to keep my house if I buy one and lose my job, and to keep up with the taxes that seem to rise higher and higher every year. This bill, as you heard, raises the tax exemption from $15,000 to $40,000 for blind homeowners, which is very modest in terms of impact on revenue, as you can see from the fiscal note. But it's huge for the roughly 1,500 blind homeowners in Maryland who would be eligible for the exemption. We estimate, based on National Federation of the Blind statistics, it would save something like $300 to $500 annually, and that the average blind person's annual income for those of us that are working is only between $15,000 and $20,000 a year. So that $300 to $500 is a true game changer for us. Property values, as you heard, has increased since 25 years ago when this last was updated, and we have not kept up with the times. I'll also refer you to my written testimony that contains more detail, and with that, I ask for a favorable report for HB 910, and I'm happy to answer any questions you may have.
Okay, we have Benjamin Danforth virtually, so for 2 minutes, please.
Thank you. My name is Ben Danforth, and I'm a resident of Rockville in Montgomery County and a member of the National Federation of the Blind of Maryland. I'm here today to urge you to support HB 910, which will increase the property tax exemption for blind homeowners for the first time in the last 25 years. My wife and I purchased our first and current home in 2019 because we wanted to settle down after many years of renting and to grow our family. However, my blindness made the home purchasing process more complex and more expensive than it normally is because of certain additional requirements. For example, since I cannot drive, our home needed to be near public transit so I could get to work, medical appointments, and stores. In addition, our home needed to be near school so I could drop off and pick up our 4 children as needed. And having a home with access to good sidewalks and road crossings was also important so that I could travel around safely and take our children to places like a neighborhood park. Fortunately, we were able to find a home that met all of these requirements, and the property tax exemption provided some extra help in making our home purchase a reality. Home ownership can help blind Marylanders have additional opportunities to live independently, form families, build wealth, and become full members of their communities. Increasing the property tax exemption for blind homeowners will help put home ownership and all its benefits within reach of more blind Marylanders. I urge you to vote in favor of HB 910. Thank you.
Okay, thank you. Are there any questions? Yep, Delegate Wims.
Thank you very much for bringing. Thank you, Madam Chair, and thank you very much for bringing the bill. I just wanted to make sure I wasn't misunderstanding. When you just said the speaker, Mr. Duncan from Rockville, that when you brought your house, you had to meet all these requirements. That's not a state or county requirement, is it? That you had to have the sidewalk, that you have to be close to the school, et cetera. Is that a law?
No, that's not a law. That's just a matter of sort of being able to live, having a house that works for our sort of needs.
Okay, thank you very much. Thank you, Madam Chair.
Oh, yeah. Any other questions? Okay, thank you all very much. Kevin Canali?
Good afternoon, Madam Chair and members of the committee. Kevin Canali here on behalf of the Maryland Association of Counties, respectfully in opposition to the bill. Understand the intent, and I can certainly empathize. I hate to be up here opposing this bill, but it is an unfunded mandate. If the bill came with funding from the state to reimburse local governments for the cost of implementing these exemptions, we'd be fine with the bill. But I'll remind everyone that we're trying to pay for the blueprint, public safety, housing, all the other things we do every day. We have no ability to raise revenue except for regressive property taxes. So we certainly wouldn't want to raise everyone else's property taxes to provide the benefits in this bill. So we're happy to work with the sponsor and with the committee to find a way to pay for this, but we can't support an unfunded mandate, especially with the current fiscal climate. We'd ask for an unfavorable report.
Okay. Any questions? All right, thank you very much. That concludes the hearing on House Bill 910. Is Delegate Robin Lewis here? Okay, I was going to skip yours, but we'll go ahead because we'll go to Delegate Roberson's because yours is a joint bill and the folks aren't here yet, so we'll come back. Delegate Roberson, House Bill 839. You can come on up.
Hey, see you. Well, thank you, Madam Chair. Thank you, Madam Vice Chair, and good afternoon to the Ways and Means Committee. This is my first time before the best committee in the Maryland General Assembly. I am so glad to be here in front of you for the first time in my legislative career, and hopefully after this second bill, it'll be the last. And I asked for favorable report already ahead of both of those. I'm here on HB 839, and for the record, I'm Delegate Kent Roberson, representing District 25, also the best district in the Maryland state. But anyway, I just want to put out that today I'm raising a bill that expands voter access and makes our state democratic process fair. And I apologize, before I do that, I just want to recognize that this is HBCU Shadow Day, and my shadow is here. Cameron, if you could stand, please, just let the people know you're here. And he's in the back. And all the other HBCU shadows, you can stand up. Thank you. And then my intern, Ayama wrote my testimony, and so if anything is wrong, it's his fault. So we appreciate you, Ayama. Thank you. So anyway, back to the bill. HB 839 will allow Maryland voters who are unaffiliated with a political party to vote for candidates in nonpartisan elections on partisan ballots. So currently, and I have a little graphic here just so you understand, currently if you are unaffiliated, and you cast a provisional ballot, your ballot does not count. And so, for instance, you have a official ballot, you can vote for everyone, correct? Got it. You all know that. If you have a current provisional ballot and say you are a Democrat and you go get a provisional ballot, your provisional ballot counts for everything except the state senate and House of Delegates. That's how it currently works. That's if you're a Democrat voting for a Democratic provisional ballot. Now, under current law, if you are, say, a Democrat and you said this time I really want to vote for a Republican, and you ask for a provisional ballot, and you pick up the Republican ballot, they're not going to argue with you or fight with you. You know, they let you know, hey, you're a Democrat registered, you cannot receive a Democratic ballot, and they say, well, I just really want to vote Republican. They're going to give you the ballot anyway. You fill it out, the Republican ballot. None of those will be counted, including the Board of Elections. The Board of Education. What we've stated here in this bill is just saying, hey, you'll take their ballot, but we all know that Board of Education is nonpartisan. Thank you to my seatmate, Delegate Miller, who is always informing me about Board of Education. And so one thing I just want to note is that what we are proposing is that this bill would change that. So we'll say, hey, we'll take it. Yes, you voted for Republican, even though you're a registered Democrat, or vice versa. We won't count those, but we will count your Board of Education individual. And so right now, that's all we're asking, is that you just include the Board of Education member in that. And just for the record, there is no fiscal note. So I think that we are well within our means to get this done this year. Thank you so much. I urge a favorable report on that. Thank you, Madam Chair.
Chair Atterbury and Vice Chair Wilkins, for the record, my name is David Naiman. I'm the president of the Montgomery County Board of Elections. I'd like to thank you for the opportunity to testify and thank Delegate Roberson for introducing this important legislation and for that excellent presentation. Our board supports this. It would allow voters who vote the wrong party ballot to have their vote for Board of Education counted. It would not allow anyone who is voting the wrong party ballot to have any of their partisan votes counted. This would treat the Board of Education race for someone who votes the wrong party ballot just like we would treat a ballot that somebody votes in the wrong legislative or congressional district. If I were to go vote in Delegate Roberson's district, where I live in a different county and a different district, I would not, my vote for county offices and for legislature would not count. My vote for statewide offices would count. If I lived in College Park and I did that, my vote for county offices would count, but again, my state office, my state legislative vote would not count. This is the same principle. This would say that if you vote the wrong party ballot, you don't get to vote if you're not actually registered in that party, but we don't throw out your vote for the one election that all voters of any party affiliation have the right to vote in, which is the nonpartisan Board of Education. It allows us essentially to accept a provisional ballot in part instead of rejecting it entirely. Under current law, we are required to reject it entirely. How does this happen? Voters go to the polls. Sometimes they forget their party affiliation. Sometimes they just want to they think we have an open primary. Sometimes there's a mistake in the voter registry. It's very rare. Sometimes an election judge can make a mistake. Whatever the reason, it shouldn't affect the Board of Education vote. It's obviously very stressful to reject votes for any reason, and particularly for this one, so I urge a favorable report. Thank you.
Okay, thank you. Questions? Delegate Hornberger.
Thank you. I'll just start at the end here. So the votes count for school board, but if they would have voted for the correct ballot, their vote still would have counted for school board.
Currently, the vote would, if they vote the wrong ballot, none of their votes count. We are required to throw out the entire ballot.
I'm familiar with that. Yeah.
Under this bill, it would allow their vote for school board to count. The rest of their ballot would be thrown out if it's the wrong ballot. Obviously, for a provisional ballot, our staff does research first, if we determine whether they voted the right ballot or not. If they voted the wrong ballot, under this bill, their Board of Education ballot would be counted. If they voted the right ballot, all of their votes would count.
So, I mean, there's some onus, obviously, on the Board of Elections staff. That's why we have them there, is to help out the voters.
Correct.
So I guess the scenario that you're outlining here is I unknowingly go into the voting booth about my party or what party I am.
There are a variety of different scenarios.
But what I'm not understanding is, in order to get issued a provisional ballot, there's a talk back and forth that takes place between the voter and the staff.
Correct.
That puts you to the provisional cohort. So if you come in and you say, I'm a registered voter, but I don't know what party I am, they'll say, okay, well, we can look you up. And they look you up and they say, you're a D or you're an R, you're an independent. In which case you vote that ballot, it counts for school board.
Okay. But imagine this scenario where.
So lay me out a scenario where this bill's needed.
Okay, so this may not be true for you, but let's suppose that you show up at the polls, you say, I want the Republican ballot, and the election official insists that on their voter registry, you are a Democrat.
Yep.
And you say, no, 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 I'm a Republican, I've always been a Republican, but our registry says Democrat. Rather than having a fight at the polls, our election officials, and this is true across the state, would give you a provisional ballot for the ballot that you are insisting that you want to vote.
Yeah, and I've watched this play out, but I worked the polls a lot, so I've heard of this happening.
Okay.
Okay.
And then in that situation, let's suppose that we do the research, we find out you're a Republican, then your provisional ballot is accepted in full. Now let's say we do the research and we find out you're actually registered as a Democrat. Then under current law, your entire ballot is thrown out, and under this bill, your Board of Education vote is saved because you would have the right to vote for it regardless of your party affiliation.
Okay. Scenario 2, I go into the primary polling location, and I'm a registered unaffiliated, and I demand a vote. Tell me what happens.
Well, it depends on what you're demanding. If you demand an unaffiliated ballot.
As an unaffiliated.
Right.
I can vote for school board.
Correct.
In the primary.
And this doesn't change that.
Okay. So
Right.
what ballot would you give me?
I'm sorry?
What ballot would you give me?
Oh, you get a regular ballot. You get a regular unaffiliated ballot in the primary if you are unaffiliated and ask for an unaffiliated ballot. If you come in and ask, if you're unaffiliated and you come in and ask for a Democratic or Republican ballot, you'll get a provisional ballot. And again, that provisional ballot, that's a good example, though. If you get the unaffiliated voter who comes in and asks to vote a party ballot, let's say they came from another state, they mistakenly think we have an open primary.
Sure.
They come, they ask for the party ballot, we give the provisional ballot, they vote the provisional ballot, and then it turns out that they can't. Under current law, we are required to throw out that ballot completely. Whereas under this bill, they would still get the chance to have their Board of Education vote count as it would have if they had asked for the unaffiliated ballot.
Okay, thank you.
Okay, any other questions? Okay, seeing none, thank you both very much. Mr. Lang is unfavorable. Yep. Delegate Roberson, you lead when somebody comes up against your bill.
Madam Chair, fellow delegates, I'm Alan Lang from Harwood, Maryland, and before the meeting, I had a nice long talk with Mr. Naiman, and he took care of the issues I had with this bill, so I am switching to favorable.
Okay, thank you. And that concludes the hearing on House Bill 839. We have with us members of the E&T committee, Delegate Stewart, Delegate Ziegler, and Delegate Morgan will be joining us shortly. So we will start with Delegate Buckle just in time. House Bill 1008. And our colleagues are here for this bill and the following bill. If you have a question, just please hop up to an empty seat. Yeah.
Let me tell you what, you're getting it done, first year out of the box. Thank you, Madam Chair. Madam Vice Chair is no longer here. She knew my bill was coming up, so she went to the kitchen, I assume. Thank you all very much. House Bill 1008, Delegate Jason Buckle presenting the bill. This bill, I think you've seen before. We have a debate, obviously, almost every bill we hear on tax day. My favorite day here is in many ways about generating more revenue and what we'll do with more and more revenue. And in the transportation field, we all understand that our revenue profile does not keep up with the costs of what many folks here want to do with respect to transportation. Some of us want to expand roads and bridges. Some of us want to expand mass transit opportunities in the 21st century. All of them cost beaucoup money, as the French would say. And so one of the ways, well, Delegate Boucher was here earlier. I wanted to celebrate his French heritage for him. Please let him know that. So what a vehicle miles travel tax would do, or a mileage-based user fee would do, these are ideas that are being, brought out as kind of possibilities. What they would do in theory, and I may not even have an objection to it if it was to supplant the gas tax. What a vehicle miles travel tax does is, rather than assess that fee on you when you fill up your car, what it does is essentially develop a system to monitor your odometer. Because we all know that electric vehicles exist, hybrid vehicles exist, higher gasoline efficiency vehicles exist. That's good, but it does alter gas tax revenues. And so there's a theory afoot to replace that potentially with the VMT. Here's the problem. We did a study of the VMT. The results were just released earlier this month. I believe there's a newspaper article about it and various media articles about it in early February. The study was conducted toward the end of that last year by a group that Maryland engaged to take a look at. What they found out was that based upon that pilot program study, the state gets about the same amount of money. You get almost the same amount of money if you use a VMT as you'd use the gas tax. So then why do we need the bill? Because you shouldn't be able to get both. If the proposal was we're going to replace the gas tax with the vehicle miles traveled tax, there may be some validity to that. The vehicle miles traveled tax would capture electric vehicle use in the same way that it would capture traditional vehicle use, and there may be a fairer or more equitable system. However, what the bill would do is it would ban us from doing this, particularly as an add-on, because quite frankly, no one's going to propose doing it just simply to eliminate the gas tax, because that wouldn't net us any new revenue, so why would we bother based upon the results of the pilot and other things? We would only do it to double tax our drivers. We're going to tax you when you fill up with gas, and then we're also going to impose an odometer-based fee upon you so that we can pay for our ever-voracious spending needs in this field. And the bill would ban that. It's not something that we typically do, but I think at some point in time, someone has to stand up for the motorists, for small businesses, for people who rely on these things and say, hey, we're going to give you some cost certainty. I'm sure all of you meet very many times with constituents, individuals, businesses, all types of things in your district. One of the number one things they say to me is, I'd really like to know where the next 2, 3, 4, 5 years of Maryland is going, because it's really hard to make investments here. It's really hard to decide whether that's buying homes, whether that's buying cars, whether that's making job decisions, whether it's making investment decisions for your small business. It's really hard when every year we come back here for 90 days and they walk out and they're like, oh, gee, I have another tax, I have another fee, we've changed the system all over again. And what this bill would do is it would prohibit that and give us some certainty. Certainty is good in life, hard to achieve, but it's a good thing to have when you can have it, that would say, hey, we're not going to do this. Other states really are not doing this. There's some pilot programs in different places, but I think this is an idea that's been bandied about, that it would be good for us to take a position right now and say, hey, we're not going to do this for the foreseeable future, and move on from that debate. Thank you, Madam Chair.
Okay. Are there any questions? Delegate Young.
Thank you, Madam Chair. So you mentioned the gas tax, but you have a blanket prohibition here. Why not do a prohibition on, or some sort of a bill that says if you only pay one or the other, as opposed to just a blanket prohibition?
I'd be very open to that type of conversation. If we address the bill through the committee process, Delegate Young, I think that makes sense to basically say that only one of the two forms of taxation could be imposed. I've found that, I think that pragmatically that is unlikely, because again, it would not highly result or likely result in a revenue increase. So there might not be as much reason to do it. But if that would be the will of the committee and policymakers to say, hey, we want to consider this, maybe technologically as things go on, it's better to do it this way than through the gas tax, but we're not going to double dip, so to speak. I think that's something I'd be very open to, and I think a lot of people would.
Thank you. Thank you, Madam Chair.
Okay, Delegate Wu.
Thank you, Madam Chair. So Delegate Bucko, you're supporting have a new tax.
Only if you eliminate the old one.
Okay.
Only if you eliminate the old one, Delegate Wu.
Let's say this, right? The EV mileage tax, when do you think it may be a proper time to propose that?
Can you say that again? I'm sorry.
When do you think it will be a proper time to propose the EV mileage tax?
I think we would have to get to the level where vehicles in the state, we are fairly even between electric vehicles or the energy efficient vehicles that are really completely depleting the gas taxes, and they're evening out in terms of their usage of our roads and bridges and the effect on it. And that's pretty evened out with traditional vehicles, gas-powered vehicles. At that point in time, I think you can really take a look and say, hey, maybe a vehicle mile travel tax or some other device makes sense because it's spreading it more broadly. At this point in time, electric vehicles are a very small percentage of the cars on the road. And I think in respect to Delegate Young's question and sort of playing on that, no matter what we do, we can't double dip. We can't take money from someone when they fill up their car with gas and then also take money from them when they drive that car away for an extra mile. So I think that has to be the major consideration.
Thank you.
Delegate Roberson.
Thank you, Madam Chair. Delegate Buckle, I appreciate the bill and do agree with you on that. I just was wondering because I agree we shouldn't, connect anything to people's cars and monitor that, but have you found any other options for using a VMT outside of, say, a monitoring system?
So it's really difficult. And in prior conversations about it, there's some privacy issues with, are you actually digitally or electronically monitoring the car? You've got a device in the car, or are you relying on people to sort of report their own mileage? Are you requiring people to come in the way you maybe with a vehicle emissions test? So you have to come in every year, and here was my odometer on, January 1, 2025, and here it is on January 1, 2026. Some of the issues with that, too, is people don't save very well. I mean, let's be honest. We have classes here or bills here every day about financial literacy classes. I'm not saying that I would save perfectly either. So the problem becomes you kind of get used to, you pay the gas tax, it's just built in every gallon of gas. If you don't pay the tax for a year and you get a vehicle miles travel tax, state may come back and say, you owe us $900. And you don't have you didn't budget for that $900 come January or whatever the kickoff point is. So the implementation of the system is really difficult to do it. Are there ways, and I think you'll see in the fiscal note and some other stuff from the Department of Transportation, there are other ways this is done for commercial trucking operations and the way they allocate things, and those are fine. I think when you're talking about vehicles moving across state lines significantly and they're trying to allocate how to get certain aspects of the vehicle tax and registration scheme, but I'm just not sure how it can be implemented effectively. In a way that would really supplant the gas tax. And as I've said, I'm 100% opposed to using it in addition to the gas tax.
Thank you.
Thank you. You're not allowed to ask questions.
Delegate, yes, he is. Delegate Morgan.
May I talk? Yep. Thank you. On the VMT, how would you consider or look at, say, we have a lot of seniors who have RVs, and they reside in Maryland, yet they travel outside the state extensively.
It's very difficult.
They travel outside on weekends out of state.
Yep.
Would that, if they want to take a 6-month trip around the nation, would that VMT then apply to the fact that they're Maryland residents, but they went 5,000 miles?
Right. I mean, under this bill, we wouldn't have the VMT, but I think under proposals that you've seen, that's one of the fundamental issues. Are there interstate commerce issues? Are there just fundamental fairness of taxation issues to say, hey, I'm taxing you, you're a Maryland resident, you titled your car in Maryland, but for vacation reasons, for family reasons, for work reasons, you may have to have racked up thousands and thousands of miles that had no impact on Maryland's roadways. You did it, you did it somewhere else. You did it in another state. And I think that's really one of the fundamental problems with it. You can fill up your car with gas and you can drive across the state line into Virginia or Pennsylvania or wherever, but pretty quickly, usually within, I don't know, maybe a couple hundred miles, a few hundred miles, depending on the gas efficiency of your car, you're going to run out of gas and you're going to have to get gas in that other state, and they're going to impose their individual gas tax or sales tax on it. Under a pure VMT proposal, you're not only going to pay the gas tax if you filled up in Virginia or North Carolina or Pennsylvania, you're also going to pay that vehicle mile tax back to Maryland. So it really is rife with the potential for double dipping and overtaxing people for using their cars.
Thank you. That's it, Madam Chair. Thanks.
Okay. Any other questions? Delegate Hartman?
You're not supposed to ask questions either.
Thank you, Madam Chair. So with a VMT, if you're paying, if that were imposed, you're kind of talking about one or the other. Mm-hmm. If a vehicle mile tax is imposed, are there structures where they're differentiated based on the efficiency of the vehicle? Or does it take away, like right now, if I buy a vehicle that gets 50 miles to the gallon, I'm paying less tax.
Right, you're paying less gas tax because
I'm
your
paying
gas
less
is
gas
more
because-
efficiently
correct.
used. Right.
So if something like a VMT is imposed, is there any difference?
No, I mean, I think you just measure you would measure the mile by the mile. It doesn't matter. So that's a good point that there's some discouragement, although there's a lot of other issues, to be fair, out there, federal issues and emission standards and things that affect gas mileage, or you know, the way that gas translates into mileage. But that definitely could be a slight discouragement for companies
From buying an
developing,
efficiency
developing
vehicle.
high energy efficiency.
I might as well, because gas is going to become less expensive, so I might as well drive the bigger vehicle because I'm paying the same tax as if I drive the tiny, uncomfortable, bumpy one.
Right.
You're worried about the bumpy golf course. I'm worried about the bumpy little car.
A pure VMT makes no distinctions between the environmental impacts or the efficiencies of your vehicle, whereas a gas tax, in fact, can encourage people to maybe, I want to save a little bit more money, so I want to get a more energy efficiency vehicle.
It's a very good point, Buckle.
Thank you.
Okay, any more legitimate questions? Okay, seeing none, thank you, Delegate.
Thank you, Madam Chair.
That concludes the hearing on House Bill 1008. Delegate Robin Lewis, House Bill 846.
Thank you, Madam Chair, Madam Vice Chair, esteemed colleagues on the Ways and Means Committee. I'm Delegate Robin Lewis, here on behalf of House Bill 486. And if you guys haven't already had an exciting afternoon, we're about to have one together, thanks to this bill. So this is the Transportation Access and Revenue Act. This is a revenue bill. I heard my esteemed colleague, the minority leader, refer to the vital importance of raising revenue and the fact that in the General Assembly this year, we're all focused on ways to pass a balanced budget and pay for the things that our constituents have told us they want, they need, and deserve. And that's a tough order. We've got to thread that needle. But they sent us here to do the tough job, and so let's try and do it. This bill aims to close the gap and increase stability of the funding stream for our transportation sector in the state of Maryland. I don't have to tell you, the members of the Ways and Means Committee, how important transportation is to our economy. I don't have to remind you that running our transportation economy actually costs us money. If we don't spend the money to ensure transportation happens, then we have no economy. So one way or the other, we're going to pay. How do we do that? It's our opportunity to get smart about it. This bill proposes a new mechanism for revenue raising for our transportation system. It proposes a sales and use tax on transportation services. Now, if you weren't excited before, here's your moment. Again, let's be fearless here and let's be dead honest. This is a bill that will impose a new set of sales and use taxes on transportation services that has the potential to create a dedicated funding stream for the Transportation Trust Fund to the tune of about $1 billion over the next 5 years. I don't know about you, but that sounds like real money, particularly when we're facing about a $2 billion funding shortfall for MDOT, as I recall. Welcome you, smart Ways and Means folks, to fact check me on the exact number, but we're talking billions of dollars in shortfall. How are we going to pay for it? Are we going to continue to nickel and dime our way to less than we deserve, an inadequate, constantly breaking down and getting patched, forever behind Virginia and other modern forward-thinking states? or are we going to do the tough thing, raise the revenue? This is a way to do it. You have my written testimony. It's got background that you guys have already heard. I won't belabor the necessity for revenue raising, and I won't remind you that it's important to get creative. This is an opportunity to do that. I urge you to give House Bill 486 a favorable report. Thank you for your consideration. I'm happy to take questions.
Are there any questions for Delegate Lewis? Delegate Griffith?
Thank you, Madam Chair. And I wasn't here when we did this, but wasn't the CPI attachment to the gas tax supposed to be the dedicated revenues fund to support the Transportation Trust Fund?
That may be. I'm not equipped to answer your question one way or the other. But I think it's a great question for the Ways and Means Committee to think about.
So I guess my question is, and maybe it's rhetorical, maybe it's not, but my question is, if we've already diverted those funds to different things for like roads and bridges, things of that nature, right, to other mechanisms, and that was supposed to be the solution, let's say we pass this and in 5 years we're not figuring out another solution. I mean, that was supposed to be the end-all solution, and now we're looking at this as another end-all solution, which means there'll just be another end-all solution at the end of the day. So can you speak to that at all?
I actually really appreciate that question, Delegate Griffith, because you put your finger on one of the conundra of adult life, and it's that reality changes, conditions change, technology evolves, the pressures of population and innovation are constantly shifting under our feet. And we're here to do the tough thing, and that's figure out how best to respond so that the needs, desires, and necessities of our constituents are met. So if we have to come back in 5 years and fix something broken, then that's what we do. What we have not done in 40 years or maybe more is raise the revenue that our transportation system requires. We've always gone to half measures because we've been reluctant to make the tough choice to maybe be a little unpopular for a minute. But I want to draw your attention to public opinion and just centering the needs of our constituents, the people who sent us here to do this very tough job. Public opinion is shifting. It may have been true a year or two more ago that the average Marylander was reluctant to even consider paying more in fees, assessments, or taxes to fund our transportation system, the improvements, the capital investments, the maintenance and operation repairs. They were reluctant. Today, I'd like to draw your attention to a recent poll, a Gonzalez poll funded by the Sierra Club here in Maryland, the Maryland chapter, that asked Marylanders, I think the sample size was 800 or 900 Marylanders selected representatively in a model, appropriate model. They were asked, would you support or oppose increased investment in public transit, walking, and biking? 78% of respondents said yes. And that includes 63.4% of Republican respondents, or people who expressed in a membership in the Republican Party. This is a seismic shift in public opinion. And what it says to me is, we have the support of our constituents to make these tough choices,
But that so question
we should do
talks
it.
about investment, does it talk about raising taxes and also raising taxes across the board like we're considering to pay for a variety of things?
Well,
Because of course everybody wants investment in these things. Are they willing to have us tax more of their dollars to pay for that investment, though?
So I think we can have the
Sorry, I'm just-
philosophical conversation offline.
No, I appreciate it. We'll catch up.
I think that's for subcommittee.
Yes, thank you.
We're neighbors. We're
Yes.
office neighbors, so
It's
we'll
good to see
talk.
you. Thank you, Madam Chair.
I hope I've at least begun to start to answer the question. Thank you, Madam Chair.
Delegate Miller.
Thank you, Madam Chair. And thank you, Delegate, for bringing the bill. Just want to, a couple of these seem a little vague, so I just want to kind of make sure I'm understanding exactly what it is. When you're talking about construction, transportation, mining, forestry, machinery, and equipment, rental and leasing services, could you talk a little bit about more what you mean by that? piece, and particularly related to construction, because construction costs being at an all-time high and construction cost of inflation, and adding to those costs right now where it is already unaffordable for many to build, buy homes, our schools, our whole infrastructure. Can you tell me how that would relate or might impact that?
Well, I think you've put your finger on an important observation, and it's that the imposition of a sales tax on transportation services would increase costs. The degree and magnitude of those increases, we can have that debate. In fact, I actually trust you guys to figure that part out. But there would be an impact. But the fact is, what's the alternative? Well, we have to think about opportunity costs, and that's another thing I believe Ways and Means takes into consideration. If we don't build a new school so that our kids learn to read, then the opportunity cost is that we create a generation of subliterate, incompetent people who will ultimately destroy whatever we leave them. So we have to build the new school. We have to train new teachers. That's why we call education an investment. It might help to remember that every dollar spent on, for example, on transit infrastructure yields about $4 in economic activity. That's why we call it an investment and not a cost. So while it is certainly the case that increasing fees, taxes, and assessments raises costs, the alternative, the cost of doing nothing, is far greater. So this is a catalytic opportunity, and I think it's worth your consideration.
Okay, and then would this be an additional, we're considering raising putting a 75-cent delivery fee on. Would this be all in addition to that, or, I mean, everything's on the table right now. So.
Yeah, I think everything's on the table. I'm not familiar with that 75-cent fee.
Okay.
This bill pertains only to the sales and use tax on transportation services.
Thank you.
Okay, any further questions? Thank you. We
Thank
do
you.
have a couple other folks signed up. Favorable with amendment, Kevin Canale and Caitlin McDonough. Caitlin wasn't here. Is she? Oh. Are you testifying? Go ahead, Kevin.
No, you can go ahead because I'm already on.
There we go. Good afternoon, Madam Chair and members of the committee. Kevin Canale here in support of the bill with amendments on behalf of the Maryland Association of Counties. You do have my written testimony. I would like to make a few points. So counties own and maintain and municipalities own and maintain approximately 83% of the roads in Maryland, but we don't have any ability to raise our own transportation revenue. You've heard me talk about property taxes and local income taxes. People think when they go to the gas station and fill up their car that their gas tax is actually paying for the roads, but that's not the case in local government. Their property taxes are paying for the roads. So while this bill does expand sales taxes and other various revenue generators to support transportation, in the bill, none of this money can go to local roads and bridges. So we would ask that if we are going to advance a sustainable solution, which MACO very much implores you to do, that we also think about roads and bridges, and again, appreciate the intent of the bill, but we do think that part of this money, if it is passed, should go to local roads and bridges, especially because, again, the state took 90% of our money back in the Great Recession and never gave it back. And again, we don't have any ability to raise revenue for our own roads and infrastructure. So with that, we'd ask for a favorable with amendments report, and I'm happy to take any questions.
Good afternoon, Madam Chair, members of the committee. Caitlin McDonough here, favorable with amendments on House Bill 846 on behalf of Southwest Airlines and some of our partner airlines who've submitted written testimony as well. We do have concerns with the provisions in the bill that would apply certain sales and use tax to air travel. We've noted in our written testimony from the Airline Coalition that there are several areas where that is federally preempted, that you cannot apply sales and use tax to an individual traveling in air commerce, the transportation of an individual traveling in air commerce, the sale of air transportation, and gross receipts from that air commerce or transportation. We're certainly supportive of the bill's efforts and this committee and the committees throughout the House for their efforts to raise transportation revenue, and particularly for that revenue that goes to support BWI, where we're a hub. Want to partner with the committee on those transportation efforts, but do think that provision in this law is preempted. I'm happy to answer any questions. Thank you.
Okay, any questions? Okay, thank you both.
Thank you.
Now, unfavorables, Peter Kitzmiller, Michael Johansson, Louis Campion, Hannah Allen, and we may have someone virtually, Regina Ali. Okay, yeah, they are here.
All right. Madam Chair, if I can go. Mike Johansson on behalf of the Washington Area New Auto Dealers Association in opposition to at least a portion of the bill dealing with the sales tax on auto repair services. The last time I testified, about 30 minutes ago, I didn't like the fiscal note. This time, I like the fiscal note. I think it did a great job. I want to direct your attention to page 5, and I don't see this very often, which is why I was very surprised. In the small business effect, it says, expanding the number of services subject to the sales tax may result in a decline in consumer purchases of these services. To the extent possible, residents may purchase services in neighboring states where these services are not taxed, or may choose to not purchase these services at all. Page 4 in Exhibit 2, it kind of reiterates this. We've reduced our estimates of taxable revenue to assume that the sale does not occur in Maryland because the additional cost dissuades the purchase or it's diverted to another state. This is a tax increase, so that I do think that's an appropriate consideration. And surprisingly, even when I've seen bills, for example, to just increase the tax on car sales, that type of analysis never makes it into the fiscal note. So I'm glad it's beginning to be something that DLS is advising you on. I think the other comment I would make, I appreciate the sponsors' kind of broad approach. Broad-based taxes, in our view, are better than taxes on single purchases, and we have testified in opposition to an increase in the car tax. But I do think a piece of the thoughtful analysis is what is the money being used for? The governor's new consolidated CTP 6-year projection spends a lot of money on transit and not a lot of money on roads. And our testimony has some charts from DLS that demonstrate that. In particular, in just 2 years, the total operating increase for WMATA and MTA is $478 million more in operating costs compared to 26 to 24. And if that's the direction, there's going to be a lot more need for more revenue. And unfortunately, most of it's coming from car users and car buyers. So we oppose the one piece of the bill, Madam Chair.
Madam Chair, members of the committee, my name is Peter Kitzmiller. I'm the president of the Maryland Automobile Dealers Association. We represent 300 franchised new car and truck dealers and their 23,000 employees across the state of Maryland here today in opposition to the specific provision dealing with tax on labor in the service department. In looking at this bill, you can't help but notice that the services that are going to be taxed are specific to transportation. I would submit that dealers and our customers are paying more than their fair share into the Transportation Trust Fund year over year. If you just look at the vehicle excise tax charged on vehicles since 2015, it's increased 32%. And so our customers are paying their fair share to take care of our transportation needs with regards to roads and transit. And I'd point out one other instance. The vehicle affordability is a big issue in our industry. New and used car prices due to shortages caused by COVID have gone from 24 to 40%. The interest rate on a vehicle loan used to be 2 to 4% less than 4 years ago. Now it's 4 to 10%. Car insurance has gone up dramatically. So the vehicle purchasing process has gotten dramatically more expensive. And the last point I would make is the average age of a vehicle in the United States is now 12 years, 8 months. It'll be over 13 years by the end of this year. A lot of that is good news because vehicles are built much better, the quality much better, but a lot of people have been priced out of the market. And those are the people that go to the service department to keep their vehicle operating. And so I think this tax is going to fall on people that can at least afford it. If you put $60 extra on somebody's services bill, they're going to drive from Hagerstown into Pennsylvania to get their car fixed. So I don't think we're accomplishing what we're trying to do, at least on this particular provision of the bill. I'm going to ask for an unfavorable report.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. For the record, my name is Hannah Allen, here today on behalf of the Maryland Chamber of Commerce, respectfully requesting an unfavorable report on House Bill 846. While the Chamber appreciates efforts to address the Transportation Trust Fund's solvency, we do have significant concerns over expanding the state's 6% sales and use tax to transportation-related services. You have a written letter outlining our concerns in more detail. I do just want to take a moment to focus on the fiscal note like my colleague here did as well. It points out in the fiscal note that many of the categories of services outlined in the bill are services that may be largely consumed by businesses. So we're impacting B2B services here. The fiscal note also states that expanding the number of services subject to the sales tax may result in a decline in consumer purchases, and that a majority of residents live within a distance, a travelable distance to a neighboring state where they can, purchase services in those states. Lastly, I want to point out that the fiscal note outlines that many of the service providers in each of these service categories the bill targets are small businesses. So businesses of all sizes, especially small businesses, will be impacted by this added tax in a state that already ranks 47th in the cost of doing business and 46th in overall business tax competitiveness. On top of that, the bill is prohibiting funds from going to the gasoline and motor vehicle revenue account within the TTF, which is primarily used to support the maintenance and operation of Maryland's transportation infrastructure by funding road and highway maintenance projects, which most of the businesses and consumers who would be paying this tax, their road and highway users, would benefit from. I will also point out, the bill sponsor rightly noted that for every $1 invested in transit, the economy can see a $4 return in economic return. I would say the same goes to roads and bridges and highway investment as well. Every $1 invested in roads and bridges and highways results in $3 to $8 in economic generation. So stop there. I appreciate your time. Thanks.
Thank you, Madam Chair. For the record, Louis Campion, Maryland Motor Truck. Sorry, I'm losing my voice today. We are here in opposition. This will dramatically drive up costs. In fact, the way this bill is drafted, I think it's unclear how widespread it actually will be. Freight transportation is a very complex network consisting of everything from air, rail, water, roads. A single product can be on multiple modes of transportation, ultimately end up on a parcel delivery truck for delivery to your home. If enacted, we would become the first state to charge a sales tax, essentially on interstate transportation because of the inclusion of air transportation and courier services. There is significant potential for litigation because there's federal preemption in Congress relative to interstate commerce not being able to be regulated by the states, particularly with regards to motor carrier rates, routes, and services. We also have a number of concerns about the impact on insurance coverage and costs, as the additional fees for motor vehicle maintenance repair will obviously go up by the amount of the sales tax. There are numerous questions about e-commerce, particularly where the Postal Service is involved and they're not subject to those taxes. So we're going to pass this tax on to private businesses that do parcel delivery and essentially are in a competition with the Postal Service. And lastly, as Ms. Allen said, this sets an unprecedented action by taking revenues generated from motor vehicles and saying you can't use it for roads in any way, shape, or form because the money cannot go into the gasoline and motor vehicle account. I'll stop there and certainly happy to answer questions. Thank you.
Okay, Ms. Ali, for 2 minutes, please.
Good afternoon, Madam Chair, honorable members of the committee. Regina Ali, Public and Government Affairs Manager for AAA here in Maryland and Washington, D.C. And on behalf of our more than 1 million Maryland members, and all Maryland travelers and motorists, AAA strongly opposes HB 846. While we certainly recognize the need for transportation funding, we are specifically opposed to efforts to impose a sales and use tax on transportation-related services such as automobile repairs and towing services. If passed, HB 846 would result in a massive tax increase impacting all Marylanders and businesses. While this bill proposes to add that 6% sales tax on repairs and towing, it would also expand the state sales tax to countless other services that are not currently being taxed, certainly impacting our, excuse me, competitiveness with neighboring states. Expanding the sales tax to include labor on motor vehicle repairs, and it already applies to parts, will further and significantly increase the cost of auto repairs. Labor is already by far the largest component of most auto repair bills. As my colleagues have also stated, this bill also prohibits the revenues from the tax increase from going to the TTF, where obviously the TTF's gasoline and motor vehicle revenue account, certainly that undermines the integrity, we feel, of the TTF, which is significant in maintaining our roads and bridges and overall maintenance of our transportation infrastructure. Finally, I will say, it looks like my time is winding down here. Another perhaps unintended consequence of the service tax would be the effect on auto insurance. Again, auto body and repair services are significant to the cost of auto insurance claims, and Maryland already has very high auto insurance rates. AAA is certainly proud to join our colleagues that are there at the table in opposing this regressive and harmful legislation. We urge the committee to render an unfavorable report. Thank you for your time and consideration.
Thank you. Are there any questions or anyone on this panel from the committee? Okay, seeing none, thank you very much. That concludes the hearing on House Bill 846, and thank you to our colleagues from E&T for joining us. Appreciate that. Delegate Roberson, House Bill 907, and you have quite a few folks signed up. I don't know who you'd like to bring up with you. I'm sure okay. I was gonna say, I'm sure you would like to call Miss Rachel Jones. I did see her.
Go across the street to Triple E, so.
Oh, okay.
She can go later.
Nicholas Healy, Sabrina Dobbins.
Wait for the chair to call you.
Elizabeth Robinson. Camille Range. And Luan Stribling. Okay, Mr. Roberson, Delegate Roberson, whenever you're ready.
Hey, sorry. Thank you, Madam Chair and Madam Vice Chair in her absence, and to the most wonderful committee in the Maryland General Assembly, the Ways and Means Committee. It's good to see you all again for, as was just named by Delegate Buckle, Kent Roberson Legislative Day. So today I am presenting House Bill 907, which looks at improving the urban agriculture property tax credit. And I'm not going to go into much detail because there's an extensive panel here for you all to ask questions of that we're really going into detail. But what it really does is just expands the urban ag tax credit to really go beyond what it currently does now. Currently, there are some who are exempted out from the program. And if you just look at page 2 on the bill text itself, really all it does is just expand it to say production of value-added agricultural products, beekeeping, raising livestock, and composting, pollinator habitat creation, and maintenance. That's all it does. The tax credit is already there. I know, for instance, in Prince George's County, it is underutilized, so we're really just looking to expand it so that those who are doing the work can actually access the tax credit, so it goes beyond what is already written in statute. For that, I urge a favorable report, and thank you all for your patience and diligence. Thank you, Madam Chair. Go ahead, sir.
Good afternoon, Chair and members of the committee. My name is Nick Healy. I am the co-owner of Communitas Farm in northern Baltimore County. In 2022, my partner Shoshana and I established a 1-acre vegetable farm in northern Baltimore County. We grow seasonal produce using regenerative and organic practices. Our commitment to stewardship extends to the land in our community. We offer fresh produce at our farm stand, provide 26-week produce subscriptions, attend local farmers markets, and distribute our food to and through local businesses throughout Central Maryland. With the support of USDA's loan and grant programs, we've been able to grow and distribute more than 25,000 pounds of food in our first 2 growing seasons. It's a common misconception that farmers need a lot of land to grow a lot of food. As we've demonstrated, you do not. We support House Bill 907, which clarifies important aspects of the urban farmer property tax credit and removes unnecessary restrictions that have created barriers to accessing the credit. This bill provides the framework for an urban farm property tax credit and grants each county the ability to implement county-level legislation that best fits their needs. Preventing small-scale farmers from receiving agricultural tax breaks exacerbates the crisis in agriculture. I think average age of a farmer today is 50 or 60 years old. They do not look like me, and I'm here to show what the next generation of farmers looks like. Beginning farmers face myriad economic and environmental challenges, and a holistic approach is needed to ensure farming remains a viable vocation for the next generation. This bill would help Maryland farmers access land and capital, the biggest obstacles facing beginner farmers, as noted by USDA. Furthermore, it treats farmers fairly, providing the same favorable property tax assessments regardless of size or zoning status. Communitas is Latin for spirit of community. Although Communitas Farm is not located in an urban area, I sit here in the spirit of community to support Maryland's urban farmers. Ideally, farmers across the state would receive tax rates aligned with how we're using our land, regardless of whether or not we're located in rural, suburban, or urban areas.
Dear Chair Adderby, Vice Chair Wilkins, and members of the committee, thank you for the opportunity to testify today. My name is Sabrina Dobbins, and I serve as the Agriculture Program Coordinator for Southern Maryland Agricultural Development Commission, or SMATIC, a division of the Tri-County Council for Southern Maryland. We are committed to expanding and promoting a viable farming agriculture community in Southern Maryland. SMATIC is committed to supporting these emerging farmers through initiatives like Maryland Farm Link, which provides resources, technical assistance, and mentorship. I want to thank Delegate Roberson for sponsoring this important bill today. Urban agriculture acts as a liaison between farming and the urban communities throughout Maryland, increasing access to fresh, local, healthy, culturally appropriate food, where grocery stores are scarce. Urban farms serve as incubators for beginning farmers, offering hands-on experience and a pathway into agriculture without the prohibitive costs of large-scale farmland. Urban farms not only sell their products directly to consumers, but also play a critical role in food security, selling or donating food to food banks. House Bill 907 ensures they can continue this essential work. Expanding this tax credit will help sustain and grow urban farms, increasing food security across the state. The original legislation allowing jurisdictions to offer an urban property tax was a step in the right direction. However, several urban farms are ineligible due to restrictions like parcel size and location in priority funding areas. By removing these restrictions, this bill ensures that more urban farms qualify for these tax credits by supporting the farmers already doing this critical work. Expanding this tax credit will not only help sustain and grow urban agriculture, but also reinforce our state's commitment to food justice, economic development, and environmental sustainability. In closing, I would like to reiterate my appreciation for this committee's support of Maryland agriculture. Your efforts are instrumental in sustaining our agricultural heritage, supporting local farmers, and ensuring food security in the Southern Maryland area. Thank you.
Honorable Chair, Vice Chair, and members of the committee, my name is Elizabeth Robinson. I'm an entrepreneur and farmer with the Garden International. I'm also the co-chair of the Prince George's County Food Equity Council, vice president of the Prince George's County Farm Bureau, and a member of the Maryland Department of Agriculture's Urban Farm Advisory Committee. I'm here today to talk to you about House Bill 907, alterations to the property tax credit for urban agriculture properties. The urban farm property tax credit was first passed in 2010 and has evolved significantly since that time through amendments. Today, very few farmers have successfully received their county's tax credit. This bill clarifies some important aspects like the location and size of the parcel and removes unnecessary restrictions that have created barriers to accessing the credit. As you know, agriculture is the #1 industry in Maryland, contributing $3.3 billion annually and 350,000 jobs to the economy as of 2022. It is widely accepted that farmers who stored over 3 acres of land for agriculture can benefit from lower property taxes through an agricultural assessment. The Urban Ag Property Tax Credit is an important step in leveling that playing field for farmers who grow food in urban and suburban environments close to the communities that they feed. As we consider attracting new companies and new industries to our great state, access to fresh, healthy foods is a driving factor in where people choose to live. Children who eat healthier meals do better in school, leading to higher test scores and better measurements of success for our schools. Communities with green spaces and gardens have better air quality and are less likely to experience pollution and crime. Most of us here can agree that we need to balance our budget, but the one thing that we can certainly all agree on is that we all need to eat. This tax credit can be a significant tool to not only help the farm succeed, but to ensure that they act responsibly by requiring relationships with the soil conservation districts, and that they must sell or donate at least $1,000 of farm goods to ensure the benefactors are farms and not gardeners. We ask for a favorable report, and thank you very much.
Good afternoon, Honorable Chair, Vice Chair, and members of the Ways and Means Committee. My name is Dr. Camille Range. I'm the Acting Director for the Prince George's Food Equity Council. I also am a registered dietitian, so I am here to promote all of the vegetables into the stomachs of Marylanders. Excuse me. The Prince George's Food Equity Council their mission is to develop and support policies, approaches, and procedures, and initiatives that create a systemic change in our local food system. The Food Equity Council currently has 35 organizational and residential members who engage in systems-level strategic planning and advocacy in order to promote a sustainable and equitable food system. In 2024, the Capital Area Food Bank reported that about half of our Prince George's residents were facing challenges of food and nutrition insecurity. And given this increase of food insecurity, this year we're taking very large steps to making sure that we're strengthening our local food economy, as well as food recovery efforts in partnership with members like SMATIC, the University of Maryland College Park, and local community food-based organizations, churches, and farms. Through innovation and technology and cold storage, we are going to support our local food system, but we need to ensure that our local urban farmers are also supported as well. This bill will ensure that Prince George's urban farmers are receiving the support that they need, not only to upstand their businesses, but also to promote the health of their local donated produce. As mentioned, $1,000 will need to be donated as a part of that contribution. So again, I'm here in support of the bill, House Bill 907, of the urban property tax, as well as the other benefits of this bill include supporting more viable economic farms, as well as being able to support sustainability through a multi-year tax credit. So we ask, again, this committee to support a favorable report for Bill 907.
Thank you. Thank you, Madam Chair. Thank you.
Yes.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. Good to be with you today. The Maryland Department of Agriculture, for whom I currently do government relations, is really pleased to support this bill. We thank the sponsor for bringing the bill. One of the major reasons why MDA supports it is because the definition that is currently in statute, that 1/8 up to 5 acre definition, when you travel the state and you look at urban farms at scale, the majority of the urban farms do not fit that definition, which means we constantly get feedback from urban farmers across the state. And while we particularly hear from folks in Prince George's County and Baltimore City, we hear from folks who are starting up new and beginning farms or urban farms in other parts of the state as well that are not zoned as agricultural. And so the definition that is currently in statute is very limited, because it means that while jurisdictions may want to offer urban farmers that tax credit, they have to go by the interpretation of the law as it is, which means they're often not able to, they have to tell farmers, you're not eligible for this tax credit. During the interim, Secretary Addix and I travel the state, and we see all kinds of farms in every single county and in Baltimore City in the state. And we have seen lots of urban farm operations where you would clearly look at it and say, this is a farm. They are profitable, they are staples in the community, but yet they would not be eligible for the tax credit with the definition as is. And so with that, we'd support the expansion of the definition and the rest of the provisions of the bill, and we'd ask the committee for a favorable report.
Okay, thank you. Do we have Luan Stribling virtually? No? Okay. Are there any questions from anyone on this panel from the committee? Okay, thank you very much. There's one unfavorable, Justin Fiore.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. Justin Fiore here today on behalf of the Maryland Municipal League in opposition to House Bill 907. Most of the time you'll hear me in this committee supporting optional property tax credits. What's different today is we're changing an optional property tax credit. So it would fundamentally change what local governments have already agreed to. The purpose for this tax credit as it was passed was to help crop production growth in urban environments. We see that as very different from other portions of this bill. It's, value-added agriculture. That means commercial wineries and breweries. Those should be separate things. So if we want to talk about crop growth and food growth, this property tax credit makes sense. We're happy to look at some of these. If we're going to talk about value-added agriculture in terms of wineries and breweries, maybe that should be another property tax credit. So that's where we are and why we ask for an unfavorable position on House Bill 907.
Okay, any questions? Okay, thank you very much.
Thank you.
That concludes the hearing on House Bill 907. Committee, our final bill of the day, Delegate Smith, House Bill 898.
Thank you, Madam Chair, Madam Vice Chair, the distinguished members of the House Ways and Means Committee. Good afternoon. I know you're all tired. This is not the best time of the day for me either, so I'm going to try to give you as much levity about a very serious matter. So I'm here to present, for the record, my name is Delegate Stephanie Smith. I'm here to present House Bill 898. And I want to just start by, stating that the obvious. We're facing a significant fiscal challenge as a state. And, I did offer a very similar bill in a much more economically advantageous time. But, then and now, the state has maintained an agreement that has ceased to be in the best interest of Marylanders. And House Bill 898 adjusts an outdated agreement with a reasonable solution. This bill repeals the vehicle excise tax exemption for short-term rental vehicles and imposes an excise tax rate of 3.5% on the fair market value of a short-term rental vehicle. Now, currently, Marylanders pay a 6% excise tax when they purchase their personal vehicles. Car rental companies, however, do not pay an excise tax on their rental fleet purchases. The car rental sector agreed to charge consumers more at the counter for their rentals in exchange for an exemption from excise tax on their fleet purchases. This is why you would pay 11.5% sales tax when you rent a vehicle in Maryland, even though the sales tax is 6% otherwise. This arrangement was offered by the sector in the 90s, 1993 to be specific, as a revenue-neutral proposal. Unfortunately, it's never been revenue neutral. By foregoing excise taxes on rental car fleets, the state of Maryland loses north of $70 million annually in contributions to the state's Transportation Trust Fund. That also provides highway user revenue to local jurisdictions across our state. This current agreement is aggressively underfunding the critical infrastructure investments we need to make in our state. This impact is far from revenue neutral. With your support of House Bill 898, we are making a modest step towards addressing a gross imbalance and a very bad deal for Marylanders. Because I'm benevolent and kind. I am not asking the car rental excise tax to be fully restored to 6%. While doing so would be both appropriate and just, I am exercising restraint by merely restoring a partial excise tax rate of 3.5%. Next, you will hear a series of industry opposition testimony to this bill delivered by many fine individuals that I do know personally. And I understand. If I was able to get away with not paying taxes, I would work aggressively and hard to retain that privilege. However, as members of the General Assembly, our constituents should be able to count on us to work just as hard, if not harder, to untether them from a very bad deal. If the original agreement had ceased to be to the benefit of the car rental sector, they would not have delayed rushing to Annapolis to receive relief, and that would have been their right. Today, I'm asking for relief on behalf of the state of Maryland because the state of Maryland's getting a very bad deal. Help me restore upwards of $46 million to $50 million annually in lost revenue to the Transportation Trust Fund. This is a mere fraction of the hundreds of millions of dollars in foregone revenue since 1993 that Marylanders have not received in this very bad deal. Thank you for your time and your careful consideration of House Bill 898, and I strongly encourage a favorable report. Thank you so much, Madam Chair.
Thank you. Are there any questions for Delegate Smith? Okay, thank you. Now we will call up some of those fine individuals that you know personally. We have Michael DiLorenzo, Don Lefebvre, Rob Smith, Louis Campion, and Peter Kitzmiller. That should fill up the chairs.
Okay.
Okay, why don't we just start from my right and work our way down.
Thank you, Madam Chair. Sorry. Sorry, Madam Chair. Still struggling with the voice. Again, Louis Campion, Maryland Motor Truck Association here in opposition to this bill. You've already heard that there's already a sales tax that's imposed, on the entire charge of a rental company's a rental vehicle, excluding fuel. I think that the sponsor's discussion overlooks the frequency with which our vehicles are overturned, and then there is excise tax paid at the time of that transaction when those vehicles are subsequently sold to someone else. So for example, according to the Truck Renting and Leasing Association, the average length of time a rental truck is kept for 5 years by the rental company. So they are turning those vehicles over very frequently, and then they're doing so in much higher volumes, obviously, than a traditional passenger car might do. Just very briefly, the fiscal report says the impact on small business is minimal. I'd suggest that that's where the primary impact is. The reality is that local rental companies and their customers, who are my members, are the ones who are most impacted by this, because they're at the disadvantage that if they don't have multi-state locations, they have to title and register their vehicles in Maryland. If you have large national rental companies, they have the ability to title in any location where they may have a facility. So this bill will absolutely harm local trucking companies, local rental companies, and we would ask for an unfavorable report. Sorry for the voice, Madam Chair.
Chairwoman Atterbury, Vice Chair Wilkins, members of the committee. My name is Don Lefebvre, and I represent the American Car Rental Association, which includes major brands to independent operators, many of whom serve here in Maryland. I'm here today to strongly oppose HB 898. This bill would repeal the longstanding vehicle excise tax exemption for rental car companies and impose a new 3.5% vehicle excise tax, making Maryland the only state in the country to disallow the exemption. The reason this exemption exists is simple. Taxation should occur at the point of final consumption. Under current law, rental car companies purchase vehicles for exclusive rental use without paying excise tax. Just like other retailers do not pay tax on items they will eventually sell to end users, their customers. This ensures that customers are taxed only when they rent a vehicle. Not only would Maryland be removing the current exemption to the excise tax and add a 3.5 tax on business inputs, it would still charge consumers 11.5% sales tax, which is one of the nation's highest tax, as required by Maryland law for each transaction. In short, we're unaware of any other state imposing retail sales or use tax on both the purchase and rental of vehicles. HB 898's double taxation upends sound tax policy by taxing both the purchase of the vehicle and the rental transaction, an approach no other state has agreed to because it's widely regarded as bad tax policy. The Council on State Taxation Cost, an independent nonprofit which examines state tax policies, has clearly stated that taxing business inputs increases cost to consumers, discourages investment, It makes states less competitive. If passed, like any new tax, the tax will ultimately be borne by the consumer, which has a downward spiral resulting in higher rental prices impacting Maryland residents, visitors, and businesses alike. In short, we oppose 898.
Good afternoon, delegates. My name is Mike DiLorenzo. I'm your local rental car operator. I've been renting cars in the state of Maryland since 1969. As a matter of fact, I was here in 1993, my first experience with legislative matters, when I negotiated with the chair of budget and tax and the vice chair, worked very closely with them to come up with a plan that would help make my small business in 1993 survive. Excise tax to a car rental company, especially if you're a small operator, is an impossible scenario because you're paying tax on your inventory before you've earned a dime. It's backwards. That's the problem. Excise tax doesn't work for the car rental industry. So we came up with a taxing scheme of 11.5%. I prefer to call it car rental tax because it only applies to car rental. It doesn't apply to anything else. Even alcohol is only taxed at 9%. So I sent all you guys a spreadsheet that looks like this, and it's really got some good information on it because I wanted to explain to you how the car rental tax really works to the advantage of the state, or the opposite of what the other delegate was saying. So John Q. Public, he buys a 2025 Toyota Camry, pays 30 grand for it, gets $15,000 in a trade credit, net taxable price is $14,800, and he pays you $890, and he keeps that car in today's marketplace for about 6 years. So the state gets $890 from John Q. Public for a brand new car for a 6-year time frame. Car rental is completely different because I'll buy probably 3 Toyota Camrys in that 6-year period because I'll cycle my cars every year and a half or 2. But I don't pay any excise tax on the purchase and sale of those cars. So I buy a Toyota Camry, sell a Toyota Camry, buy one, sell one, buy one, sell one. But I only have one car in service every day for 6 years. And during that 6-year period, that one Toyota Camry will produce $9,522 in sales tax for the state. Thus, you end up with a ratio of car rental generating taxes 10.7 times more than the average citizen who buys the same brand new Toyota Camry over the 6-year period. So to characterize this as an underpayment is absolutely absurd. My customers are not out-of-state renters. My customers in Prince George's County and Montgomery County.
I'm going to have to ask you to wrap up. I'm sure there's going to be some questions.
Okay.
I'm certain
sorry.
there will be questions.
Madam Chair, members of the committee, my name is Peter Kitzmiller. I'm the president of the Maryland Automobile Dealers Association. We represent 300 franchise new car and truck dealers across the state of Maryland. Here today in opposition to House Bill 898, I want to talk specifically about dealer vehicle service loaners. The trend in our industry the last 15 years has been when you buy a new car, or you buy a car from one of our dealers, you bring it in for service, we offer a complimentary service loaner vehicle for you to use. And it's no longer just luxury brands. It's expanded down market as well. There are a number of Hyundai dealers or a number of Honda dealers that now offer complimentary service loaner vehicles. Obviously, if the vehicle's complimentary, this is a cost to the dealership. It's not a revenue generating portion of the dealership. So this is costing us money. Now, the reason we do it is customer satisfaction, and you'll hear from Mr. Smith here in a minute who will explain that in more detail. Customer satisfaction then creates, customer loyalty. Those are two very, very important things to a car dealership. If we have to charge the customer a fee for a complimentary loaner vehicle, it defeats the purpose. Again, this is a service that our customers now expect. It's kind of a cost of entry in the new car and truck dealership business now, offering loaner cars, and we think this would end the program, frankly. We can't be paying 3.5% excise tax on a loaner fleet for a single dealership that has 40 vehicles in loaner service. It's probably north of $400,000 a year in taxes, which we can't operate. And if we pass it on to the customer, again, we're defeating the purpose of offering a complimentary vehicle. So we would ask for an unfavorable report.
Good afternoon, Madam Chair. My name is Rob Smith. I'm the president of Fitzgerald Auto Mall. It's an employee-owned company. We have about 1,300 employees in Maryland. Proud to be represented by Peter Kitzmiller here to my side here. And I want to echo the remarks and tell you why we're opposed to this. We do offer loaner cars, and we have. It's been a hallmark of our business model for a long time, and not all our dealerships are located on mass transit. Those consumers need to be able to get to work and take their kids to school. Those cars turn probably every 90 to 120 days, not even as long as a rental car company might keep something for 2 years. For us to be able to pay 3.5% excise tax on that would make it impossible for us to maintain a loaner car program for the future, and it would be detrimental to the consumer. So for that reason, we oppose this, and my concern is my competitors will have an advantage in other states that all can be reached in a short amount of time. Maybe they'll have their car serviced there, and you won't get the revenue on the service either. So thank you for hearing me testify.
Okay, we do have a couple questions, and I will just remind the committee, we have 3 other folks that are coming to testify after this panel, so they might be able to answer your questions as well. I just have a couple of questions myself about this loaner business. I mean, one, I'd be mad as heck if I had to pay for my loaner, so. But one, everybody doesn't offer that, I don't think. You said everyone offers a loaner vehicle.
No, I didn't say, if I did, I missed out. I apologize. No, not everybody offers it, but
Okay.
it is, 10 years ago, it was a Lexus dealer, it was a Mercedes dealer. Now it's across the board. But no, not everybody offers loaner cars.
Okay, and could either of you 2 gentlemen explain to me, if it's a loaner and it's not a rental vehicle, why would it be subject to this excise tax?
It's not carved out. It's actually because it has to be put on and registered under the name of a company, which then is looked at as a sale. So in our case, it's registered to a rental car company.
Okay.
And so now it falls under the rental car definition.
But you could change how that's done, right? Like, you wouldn't have to register it to a rental car company. You could register it to Fitzgerald, I don't know, whatever you sell.
In some cases, the cars are new, and I can put dealer tags on them. In other cases, they can't be new. They have to be sold as certified pre-owned at the end of their life, at the end of the use of the vehicle. And in those cases, they have to be registered under a different name.
Okay.
Because the manufacturer program requires it.
Okay, I think I'm not super clear on that, but we can talk about that offline. Delegate Hartman.
Thank you, Madam Chair. Appreciate you being here today to help us through this. The chair's question actually raised another question for me. So a loaner car, I thought was like a new vehicle. So I recently purchased a loaner vehicle, and I'm thinking I probably paid 90 or more % of the market value of that car, and I paid 6% tax on that. So did I not buy a new car?
By definition, it depends on the definition that the state has and how many miles are on the vehicle.
So it's 6,000 miles. They say these loaner vehicles, every 6,000 miles, like you're saying, they're only a loaner vehicle for a few months, and then they're put on the floor.
And some are longer, some are shorter. It depends on the manufacturer. In some cases, they are used vehicles, but there's a prior use disclosure that goes along with it. So you've obviously known what you're purchasing, a vehicle previously used as a loaner vehicle, and so there is a disclosure. It depends. Sometimes the consumer wouldn't see that as a new car. They'd see that as a gently used car. But the state has a definition, I believe, about how many miles.
Yes.
Before it's no longer a new car.
Okay, I'll follow up offline. Thank you.
Okay, Delegate Buckle.
Thank you, Madam Chair. I had, I guess, 2 questions. One is sort of maybe each side, leaving Mr. Campion's group out a little bit, each side of the transaction. So for the rental car companies, the gentleman in the middle in particular, one of you testified that what it sounded like to me, it sounds like double taxation. It sounds like you're paying taxes at every point of the transaction differently than anybody would. Can you explain that a little bit more of how, if this bill were enacted, I'm paying a vehicle excise tax the same way that I would if I was you indicated if I was just a purchaser for private use, and then because I'm using the vehicle and I'm getting exposed to this 11.5% tax, I'm paying more and more and more and more. I'm paying for the car every which way but loose. And it sounds to me that the only way you could even, I don't even think you could break even, but the only way that you could ameliorate that would be to dramatically reduce the 11.5% sales tax on the rental transaction. Is that even a possibility? If we reduce that to, say, 6%, would it even out?
Back in the 90s, what we had was 5 and 5. We paid 5% excise tax and we paid 5% sales tax, and that was the double taxation. I sent many of you a copy of a letter from Governor Glendening when the Sunset Bill passed in 1998. So it was a double taxation issue that the legislature was concerned about because it was being taxed twice. That was one of the many reasons why we ended up on this taxing scheme of putting the tax at the end of the transaction instead of the beginning of the transaction, because at that time I was a small business and I was getting hurt the most in the state.
Right.
So it really hurts small business because you can't finance the tax when you're a car rental operator.
Right.
No bank or finance company is going to finance the tax. You got to pay cash.
And my suspicion is that by raising it to 11.5% from 5%, there was actually an analysis probably that said, hey, we're revenue neutral. We're getting our revenue back because we're going up on the
Revenue neutral thing came the other way. The legislature demanded revenue neutrality in 1993. They set a $20 million goal for the car rental industry, had to generate $20 million in tax, and they didn't care how we did it.
Okay.
So they passed that bill first in 1993, and then in 1995, the industry came together and came up with this taxing scheme. But
Right.
in rebuttal to the delegates' statements earlier, we passed this taxing scheme, and then Virginia copied Maryland's taxing scheme, and then Washington, D.C. copied Maryland's taxing scheme. So if it was such a bad deal for the jurisdictions, then why did around the entire country, every state has copied the same taxing scheme? So
So we're the only state that would want to do it now. If the bill passed, that we're going to take it up front, and then we're going to take it on every transaction for the car. And then when you eventually sell the car, then we're going to impose a tax on that too, on that transaction.
Correct.
So the other question
get
that I
less
had
cars.
for the loaner industry, and it's the same kind of thing, you still either pay taxes or taxes are incurred when you're finished with that loaner car. Let's say it hits 6,000 miles, you sell the car, and someone then pays the full sales tax on the purchase of that car, correct?
Correct.
So it's not as if you avoid the taxation for the sale of the car. You're just saying during that limited period of time where you're using it basically as a free rental car for your business, you'd now have to, under your reading of this bill, you'd now have to pay the excise tax. You couldn't afford to do that. And then, but when you sell the car, it's not like you're getting away scot-free from the sales tax transaction. It's just basically the difference of a few months or a little bit longer than getting that car from 20 miles to 6,000 miles, and then you sell the car.
Correct.
Okay. And if that was taken out of the bill, if your industry was taken out and said, hey, this doesn't apply to essentially free rentals or complimentary rentals, then it doesn't affect you as much. Is that fair to say?
From the new car dealer perspective, that's the major concern.
That's the major
yes.
issue.
I have some dealers, Mr. Fitzgerald being one of them, that do rental cars, but not nearly a significant number of our members do loaner cars.
So if you're a rental car company, you're getting hit with what we just talked about, how you're getting triple taxed
Correct.
in a way. And if you're just a loaner car industry, you could resolve that by taking you out, but it wouldn't solve all the problems.
Correct.
Thank you for the clarification.
Delegate Miller.
Just a couple of clarifications. So I appreciate the analysis and the chart that you provided. Was there any discussion, or have you seen anything in any of the concerns or letters that then the 11.5% would be removed, so you wouldn't have the double or triple taxation with the bill if it's such a bad deal for Marylanders? Did you see anything along those lines? Because I'm assuming my reading of the fiscal note is that it did not take that into account. We're leaving everything with that 11.9% still intact. Whereas I think it would be a very different fiscal note if we remove that 11.9% so that you didn't have the double taxation. Can you guys speak to that, especially in light of the chart you provided on what kind of impact that would be if the 11.9% were repealed and you were just left with the current bill?
The best information I have is that the 11.5% generates about $45 million a year for the state. but that's not mentioned in the fiscal note, which blew me away. I couldn't believe that it's like ignored. It just says 11.5%. Normally, when I come down here, it all calculated out, and it says we're paying $45 million a year, and now they want to tax another $46 million a year, I believe is what the number was in the fiscal note for the first year of the excise tax. So that would be doubling the tax from 45 to, what is that, 91?
Okay.
Okay, so that's what is being proposed the way I took it, but, I'm just a dumb old car guy.
No, that's what I was trying to get to, exactly how much of that was being brought in, because I didn't see it. Thank you.
Delegate Wims.
Thank you, Madam Chair. I worked for 4 years at the Small Business Administration in Washington, and I was sort of surprised when I heard, I think it was Mr. Champion, is that how you pronounce it?
Champion, yes, sir.
Champion. Could you explain that, as you see it, how it would hurt small businesses in the state of Maryland?
Well, because if you don't have a location outside of Maryland, then you have to title and register your vehicles in Maryland. So if I'm a larger, excuse me, I'm really sorry. Sorry for the voice hiccups here. So if I have a location, let's say in Virginia, let's take a company like Penske, right? Big national company that rents a lot of trucks. Well, Penske has locations in Virginia, they have locations in Maryland, they have locations in Pennsylvania. There's nothing to stop me from titling and registering all of my vehicles in one of those other locations. Whereas another company, Brody Truck Rental, member of ours in Baltimore, they only have a location in Baltimore. They have no option but to register and title in Maryland. And so they would be subject both to collecting the sales tax that's already in place and paying what would be a 3.5% excise tax, where a company like Penske could simply avoid it by titling and registering elsewhere.
Thank you, Madam Chair. Thank you for the answer.
That's unless we say something like, if you have your vehicle fleet here, you have to have them titled and registered here or a certain percentage.
So, Madam Chair, so now you're opening up something much, much broader called the International Registration Plan, which you don't want to do, actually. It's a national program, including Canada, that is a registration program that's recognized by every state, and you are allowed to register in any state where you have nexus vehicles over a certain size for commercial motor vehicles. It ensures that Maryland gets its percentage based on mileage that is run on registration fees. So if I run 50% of my miles in Maryland, 25% in Virginia, and 25% in Pennsylvania, I pay 50% of Maryland's registration fees, 25% Virginia, 25% Maryland. So I get paid nationally.
Okay.
So, yes, ma'am.
Quick question, and then Delegate Wells has a question. What is, a very brief answer, if this were to, legislation were to pass in some form, but, there was a sunset put on it, would you still be opposed to it?
Absolutely.
Yes.
Okay. Delegate Wells.
Thank you, Madam Chair. So I guess I wanted to raise, I have kind of two questions. One, oftentimes our good colleague, the minority leader, he oftentimes mentions a lot about what Virginia is doing in terms of, their corporate tax rates compared to Maryland's corporate tax rates, so on and so forth. And you mentioned, one of you on the panel, I forget who it was, it may have been you in the middle, you kind of alluded to the idea that people would leave the state to go to get their vehicles. You mentioned Pennsylvania, and you mentioned, I think you mentioned Pennsylvania, but I know for a fact you mentioned Virginia. And then you mentioned how when Maryland passed the initial exemption, however many years ago, that a lot of places, other states took note. But we know that this is focusing on our transportation. So I'm curious if you can just kind of help us connect the dots, because I think it's also important to think back to the overall goal of what this is supposed to accomplish in terms of much needed investments here in Maryland in the way of transportation. But you're giving us examples of states that have a very different landscape when it comes to what their transportation system looks like. So I'm wondering if in regards to that, if you can give any of us on the committee a response to what we should do to help find investments for our transportation, and why this much smaller, the small piece of repeal of your current exemption, why we should not be focusing on that.
Well, I can speak to the statement about somebody going to Virginia. I think what we're saying is that if this tax is imposed on complimentary service loaner cars, it's going to result in dealers in Maryland being unable to offer that benefit to our customers, where somebody over in Tyson's Corner is going to still have a complimentary vehicle loaner program. And so that's something that a consumer is going to take into account when they decide where to buy their car. And if they go to buy the car in Virginia because they're going to get a loaner car, they're going to take their car for service in Virginia, which means my dealers aren't going to be doing the service. We're not going to be paying taxes on anything. Our technicians not going to be earning. So that from that limited perspective from our industry, that's our concern about the other states.
On the loaner program, because I know the chair raised it, how many people are using the loaner vehicle when they go to get their car serviced? Like, I get my car serviced twice a year, maybe actually only once a year. And typically, I get it somewhere nearby here in Annapolis where they have a shuttle service and they will drive me typically back here to the State House because it happens during session. So I'm curious, like, how often are people using these loaner vehicles? I mean, I see them on the road, I do. I can't tell you that I see them every day, however, but how often is that even the reality?
I think up to probably, I mean, this is anecdotal, 60% of our members offer loaner car programs.
But how many cars are they normally, like, how many loaner vehicles does an average dealership have in fleet? And how many are they loaning out on a daily basis?
I'd have to double check numbers, but I mean, I can tell you from a sales perspective, we sell around 22 to 23,000 new and used cars a year in my organization. 50% of those customers choose to get a loaner car. They get a loaner car option. So those people are coming in every 3 to 6 months to have routine maintenance. So there's a substantial number of customers. And, you know, I'm in Hagerstown and Frederick and places that don't have metro or buses, and those people need to be able to drive. Not all loaner car vehicles have any emblems on them. You can't tell it's a loaner car. It looks like a regular car.
I was going to say, I thought they all did because I figured that's a great marketing opportunity.
Yeah, we're missing the boat.
Yeah, we are definitely missing the boat.
At least it used to be. And I think that just the last question I have is, the fiscal note says it's a minimal small business impact. I don't know if I completely understand from what I've heard today that is the case. So can you make one last ditch effort to explain to me how it's not a minimal? I mean, based off of Department of Legislative Services, who are pretty good at their job. I know we don't always agree sometimes with their assessment, but can you just give me one last ditch effort to describe why it's not a minimal business impact?
Okay, no business in the state, not any, none, zero, pay sales tax on their inventory. Nothing. So I was going to call it head company, Macy's. When they buy a pair of blue jeans, okay, they don't pay sales tax and then put the blue jeans on the shelf and then sell them, okay? They buy the blue jeans, put them on the shelf, and when they sell them, tax is collected from the customer and then forwarded to the state at the end of the month. In this scheme, this tax scheme, what you'd be doing to small business car rental companies is they have to pay the tax up front because you can't rent the car if it doesn't have license plates or a title. So you have to pay the tax with no customers and no income. So you have to come up with that money somewhere, and your bank will not finance that tax. So you can't borrow it from the bank either. So you have to have cash to do that. So that makes it next to impossible for a small business to grow. So what will happen is if you guys pass this tax, what you're going to end up with is fewer rental cars in Maryland. The small companies will be exiting the business, and the larger companies, it'll be just like it was back in the 90s when I would go to, well, back then it might have been called Friendship Airport, I don't remember. But back then, you would go to the airport in Maryland, and all the rental cars would have Virginia plates on them. Because the dominant airport back then was National Airport. So that's what's going to happen if you go back to this taxing scheme of taxing the inventory. Because what you're doing is you're not thinking of it like a businessman, you're thinking of it like government. So from a businessman's perspective, you're taxing the inventory before we can earn any money. So how are we supposed to pay the tax? Where do you get the money from to pay the tax? That's the problem. You got to pay the tax before you can generate the revenue. It's backwards. I don't know how to say it any different than that. I can see you guys, I haven't turned your light bulb on, I'm sorry.
Okay.
Thank you.
Any other questions for this panel? Okay, thank you all very much.
Thank you.
Next, Michael Johansson, Andy Dolph, and John DeRose.
All right, good afternoon. I realize we're the last people, so we will try to be as efficient as possible. Madam Chair, members of the committee, my name is Andy Dolph. I'm the Vice President General Manager at Enterprise Mobility. We are a large rental car company operating Enterprise Rent-A-Car, Alamo Rent-A-Car, and National Rent-A-Car. This would cripple us as well. As mentioned, we already pay the 11.5% tax, which is one of the largest in the United States already. My good friend from NextCar, he mentioned how much it was. Just I'll give you some Enterprise numbers. The 11.5% tax last year from Enterprise alone in the state of Maryland contributed $44 million. Okay, that's up $7 million from just 5 years ago. So us alone are contributing $44 million due to that 11.5% tax. So on top of that, we have registration costs of over $4 million, payroll taxes of $5 million. Our overall economic model to the state is over $177 million. We are a Maryland business. We employ over 1,500 Marylanders. We have over 100 local car rental offices, okay, on top of multiple truck locations and multiple car dealerships throughout the state. And we have 2 regional headquarters in Anne Arundel County and Montgomery County. Costs in the rental car industry, Mr. Peter mentioned, costs are rising. I'll give you just an average model out there. A Dodge Durango that was $30,000 5 years ago is now $40,000 today. Okay, so the costs are rising across the industry. When your family and friends come and visit you at BWI Airport, once session is over and you beg them to come see you to enjoy some time together, that $40 rental car, the reason it's $60 is because we are one of the largest revenue streams for BWI Airport. We collect the 11.5% tax for the state. We also collect transportation facility charge on top of an 11.1% concession fee, okay, which that revenue stream goes directly to BWI, okay? The $40 rental car ends up being $60 for a reason. It's a 48% of that is taxes and fees. For that reason, we urge an unfavorable report on 898.
Good afternoon, Madam, or almost good evening, but good afternoon, Madam Chair, members of the committee. My name is John DeRose. I'm also with Enterprise Mobility. I work out of our office in Montgomery County. My territory is Montgomery County, Prince George's County, Southern Maryland, up through Frederick, North, and DC and Virginia. I'm also here in opposition to HB 898. I'm going to try not to be too repetitive since we've had a lot of testimony and questions. But I think the tax component of this is important to make sure that we all walk out of here with, I guess, the same understanding of the concerns we have with the tax. It basically violates or breaches 2 basic tax tenets in business. The first is sales tax is only a tax on the consumption of goods to the end consumer. That's the first. The second, sales tax is not a tax on business inventories. And I know Mr. DiLorenzo was trying to explain that. I thought he did a pretty good job. But it's really a basic business tax tenet that's being breached here if this bill were to pass. By passing this bill, Maryland would create an environment of competitive harm in the rental car industry. Tax policy shouldn't be the result of picking winners and losers. To the extent possible, it should be a neutral process. HB 898 not only increases business inventory costs for the rental car companies, but it would make all rental car operations in Maryland very competitive, and I think our neighbors in Pennsylvania, Delaware, Virginia, and in the District of Columbia would be happy with that passing. It would create more business that would go across the borders. We have 100 branches in Maryland, and many of them are around the borders. For example, you know, if our branch in Oxon Hill had to absorb this new tax, our customers would literally just drive across the bridge to go to Alexandria. We urge an unfavorable report on this bill, please. Thank you.
Thank you, Madam Chair. I'm Mike Johansson on behalf of Enterprise Mobility. Mr. DiLorenzo and I sat in that room across the hall in the old building with the cigar smoke and everything else that was going on in Ways and Means at the time. And
what had happened was rental car industry bought inventory, their cars, and kept them for many years. They would keep them 3 to 5 years or longer. And when the U.S. auto manufacturers, GM and Ford, got into difficulty, they convinced the rental car companies to buy a new car every 4 months. And that 5% excise tax changed it from something that was a burden to something that was abominable. So the state of Maryland worked with the industry to recognize, well, wait a minute, if it's your inventory, we shouldn't tax it at the time you buy it. You are going to sell it to a customer on a day-by-day basis until you sell the car to a customer at 6% when they buy it. So they kind of came to the right place from a policy perspective, but the ask of the industry was to then find a way to make the state whole. We came up with a crazy mechanism that we got credit for all the excise tax we paid against the sales taxes we were paying, and that didn't work. Then we got an exemption from the excise tax, and they set the sales tax at 10% that was paid over time, and that wasn't quite enough. So finally, we wound up at 11.5%. That's kind of how we got to where we are. But from a business policy perspective, it matches. You don't tax a business's inventory before they have a chance to sell it. Delegate Wells, we appreciate your co-sponsor of this and your primary sponsor. If you need to raise more money on rental cars, we wouldn't advocate it, but you got to set the tax rate at 16 or 17% and just live with the fact that's what you need to do. Putting the burden on the business at the time they buy the car disrupts the business. And honestly, we're going to pass the costs along anyway, so we'll get to that same type of burden on the consumer. So we appreciate the situation that you're in globally, we really do, but this is just the wrong way to get there. Thank you.
Delegate Roberson.
I was hoping the vice chair would go first, but I'll go. Going to your point, though, on raising the tax to 16%, so you're saying instead the consumer would pay the 16%. Is that what you're saying?
I'm saying the consumer's going to pay. If the cost of acquiring the cars goes up because these guys are paying tax on it, $30,000 car, let's go ahead and add another $1,000 to it. When they set their rental rates, they're building that cost in anyway, right? That's all they have is the cost of their car and the cost of maintenance. That's how they set their fees. So the consumer's going to pay. The point would be you're collecting it at the time it's used, which means it's coming out of the revenue from the consumer rather than fronting that cost up front, which is what this bill would do, shift the burden to the.
And what's the current tax rate now on the consumer?
It's 0 when you buy the car, and it's 11.5% when customers rent the car.
For the rental, yes.
Yeah.
Okay, thank you.
Yeah, let me just add one quick thing to that. The 11.5% tax is already one of the top 3 highest in the United States. So we're already at a incredible threshold. And one of the pieces to remember is our rental car locations are our in-town operations. We are renting cars, not just at BWI Airport. We're renting cars to customers that have been involved in accidents, cars that are having their cars serviced, cars that are needing to be maintained. So we're not just at the airport. We're providing goods and services to people that have their car down and need transportation to get to work. So a tax increase would also be unfavorable because that would burden the customer on that part.
Yeah, and for that point, that's also why I don't rent from the airport, because your tax is higher, correct, at the airport than you are off-site. Am I correct?
Yeah, we have to collect all these other concession fees already for the airport, correct?
Thank you.
Delegate, the actual tax rate is the same. If the tax rate's the same at the airport as it is in the home city, what we call, but you have all the other added expenses.
It's a convenience fee and it's correct. Thank you. That's what I thought. Thank you.
The vice chair.
Thank you, Madam Chair. I want to thank the bill sponsor for bringing this bill. This is the second go-around in my time in the committee, so it's always an interesting conversation. I wanted to better understand, as a larger company, the last panel we heard a bit about the impact, particularly for smaller businesses. As a larger company, though, I'm not sure that I heard the specific harm. I understand this will be a pass-through to consumers potentially, but you started the discussion talking about how it would be debilitating to your company. I'm not sure that I heard that actually unpacked as a larger company. So if you can talk more about that?
Sure, and I can get you some specific figures later on. I don't have those in front of me. I think bad tax policy cripples large businesses and small businesses alike. That was the point I was trying to make there.
Okay.
I think at the end of the day, if I can just add on to that a little bit, if you take any expense or any cost that's associated with running a business, and obviously tax is a big one with every business, and our tax rate being 11.5%, the highest in the country, if we increase that another 3.5% as is being proposed, that just pushes the break even of our service that much higher. And that cost, as Mike was alluding to, passes right down to the end user. And in Maryland, with our 100 rental branches, one of them's at the airport. So it's really your constituency that's going to bear the burden of this. And from a company standpoint, it makes it more difficult if our business goes down because of this and, our growth isn't there, to invest more money in our Maryland operations when we could invest them in Pennsylvania, Virginia, the district, any of the neighboring states where, it may be a little bit more robust around those edges where people will just travel right across the line. If I rent a car in Pennsylvania, it's 10% or 20% cheaper than in Maryland. And I live right on the border. Or if I'm in Oxon Hill, I can run right over to Alexandria and rent that car for, 20% less. So that's kind of how it impacts a larger business like us. But I think a big misnomer in the rental car business is we're taxing out-of-staters a lot through the airport rental operations when, as I mentioned, we have 100 locations, only one of them's at the airport.
Thank you for your responses.
You're welcome.
Delegate Wims.
Thank you, Madam Chair. And this is going to be a yes or no question because it is very late. I'm a big fan of BWI. So the question is just yes or no. Has BWI weighed in on this at all? Just yes or no?
Not that we're aware of.
Not that I'm aware of.
Okay, thank you. That's all I need to know.
Delegate Miller.
Again, real quick, so I'm interested in, would you say there could be an equity impact on this? Because a lot of people that if they do have to put their vehicle in for repairs, or if they don't have if they don't have a reliable vehicle or a second vehicle, they really rely on that rental aspect. Or if they don't have a car and then they want to take a trip or go somewhere, they really rely on that rental market. And they rely on a lot of the small companies that are possibly outside the airport or in their local market. Would you say there might be an equity impact as well on that?
For sure.
And,
There
okay.
definitely would be, yes. Yeah.
Thank you.
Okay, are there, Delegate Miracunoy.
Thank you, Madam Chair. Just to be clear, an excise tax, it's a choice to pass it to the consumers, correct? It's not collected at the point of sale, correct?
Correct. It's a business cost, correct?
Okay. I'll leave it at that. Thank you.
Okay, thank you very much.
Thank you, Madam Chair.
Thank you.
Thank you.
That concludes the hearing on House Bill 898, and that concludes the bill hearings for the Ways and Means Committee. Subcommittee chairs and Buckle, I will see you in 3 minutes.